right, there we go. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, February 5th, 2026. We have 11 bills on the docket. We're going to start off with Senate Bill 298 with Senator Henson. We'll then go to 302, 294, 334, 290, 327, 321, 315, 330, 331, and we'll wrap up with Senator Muse with Senate Bill 320. Senator Henson, the floor is yours.
Good afternoon, Mr. Chairman. May I bring up the panel? Thank you. Good afternoon, colleagues. For the record, I'm Senator Shanika Henson, representing Legislative District 30, here to present Senate Bill 298, Department of General Services, Capitol Police Statewide Jurisdiction. This bill should feel familiar because the folks that are mentioned in it should feel familiar because we all frequent state buildings, including the one that we are in right now. When we're in our state buildings, we have the benefit of being protected by Department of General Services police officers that are in and about those buildings. Their jurisdiction extends to a 1,000-foot perimeter around those buildings, and this bill would give them that jurisdiction but expand it to a 2,000-foot perimeter around those buildings. It also gives them some additional opportunities to coordinate with local law enforcement. Many of you have had the opportunity to have conversation with the Department of General Services to hear from them directly why this bill would be so impactful to the work that they do. And I hope that in those conversations, you all have heard from them the level of coordination that they're able to provide to our local law enforcement departments. With that, Mr. Chairman, I would ask for a favorable report on this bill, and I would turn it over to the panel.
Mr. Chairman, Mr. Vice Chair, members of the committee, for the record, I'm Atif Chaudhry, Secretary of the Maryland Department of General Services. I'm here today in support of Senate Bill 298. First, I want to thank Senator Henson for her leadership in sponsoring this legislation. We are respectfully asking the committee's support of SB 298 to ensure that Maryland Capitol Police officers are fully authorized to enforce Maryland's criminal and vehicular laws on a statewide basis. The bill will expand their primary jurisdiction authority from 1,000 feet to an industry best practices of 2,000 feet around all state-owned and leased facilities, and require MCP to provide notice to other state and local law enforcement agencies when operating interjurisdictional law enforcement activities. SB 298 is needed to fill a critical gap in MCP law enforcement capabilities, including routine cooperation with other agencies and specific actions such as issuing citations, making arrests, issuing summons, and making welfare checks. MCP officers currently do not have statewide jurisdiction under current law and are unable to perform law enforcement actions outside of a very limited perimeter, making it frustrating and confusing for officers as well as members of the public. The law enforcement functions of MCP are inherently statewide in scope, and threats to government operations, facilities, and personnel are increasingly in volume and severity and do not respect jurisdictional boundaries. Without statewide authority, MCP is often forced to rely on jurisdictional handoffs, lacking the power to conduct follow-up investigations, act credibly on intelligence, and execute enforcement actions. In these ways, the lack of statewide authority threatens an unnecessarily fragmented threat response. I want to take a quick second to thank Colonel Lilly of Natural Resources Police, Acting Chief Miguez of Annapolis Police Department, and Chief Franca of Morningside Police Department, all here today in support of this bill. And we've worked out with state police some friendly amendments to the bill, and they are also in support of this bill as well. Again, persons of interest and threats of violence are not confined to the vicinity of state facilities, and MCP stands ready to serve in an expanded capacity and in a statewide capacity. Therefore, I respectfully request a favorable report of Senate Bill 298. Thank you.
Good afternoon, Chairman Smith, Vice Chair Wall-Striker, and members of the committee. For the record, I am Lieutenant Colonel Glenn McGuire, the Deputy Chief of the Maryland Capitol Police. Thank you for the opportunity to testify in support of the Senate Bill 298. So here's the reality. Although the threats have increased in today's environment, we cannot fully and completely investigate credible threats to the lives of staff, employees, or even legislators. If those threats require us to enforce laws beyond 1,000 feet of our 1,400 buildings that we protect across Maryland, We have had 2 bomb threats against 2 of our dignitaries. I was able to coordinate with the Baltimore County and Baltimore City Police at that particular time, and the chief was very frustrated that we did not actually have jurisdiction there. Our officers are highly trained and certified by the Maryland Police and Corrections Training Facility. I am actually one of their instructors, and I have a 35 years worth of experience of detective experience. We hired a new major from the CIA Police with over 20 years of experience as well. Some of these expertise that we have, as well as our agency members, is criminal investigations, arrest warrants, crisis intervention, hostage negotiation, and active shooter training, where I was fortunate to be able to train the actual governor's civilian staff. We train our ally agencies, and some of our equipments are body-worn cameras, license plate readers, centralized dispatch center, statewide camera access, and we've conducted over 1,200 traffic stops annually. We also provide support such as K-9 and various supports, and we also receive various requests for assistance from Annapolis Police Department and some of our ally agencies as well. We engage with all Marylanders from the unhoused to mental illness, and we are trained to de-escalate and report professionally in all these situations. So that is our mission. That is why we are here today, and thank you for your attention as we urge a favorable response.
Excellent. Thank you very much. All right, questions from the committee. All right, Senator, Vice Chair Wall-Striker has.
Thank you, Mr. Chair. I don't know if we know the answer to this, and perhaps we can find out if not. So a bunch of us who represent Prince George's and Montgomery County have transit police in our jurisdictions, but the transit police have jurisdiction off transit property, but I think have a buffer as well. Do we know what the WMATA police buffer is? I'm just trying to come up with an analogy to what you guys are doing. And if not, could we find that information?
You can take the podium.
I'm sorry, sir. Wanted to see, what was the question once again, sir?
I'm just trying to find an analogy for the buffer as we try to find the right number here, and I have no doubt that perhaps the bill itself is the right number. WMATA police, the transit police that work in many of our jurisdictions are allowed to go off WMATA property, but they themselves have a buffer as well. Again, I'm just trying to analyze by analogy. Do we know what that buffer is? And if not, do you think we could find out?
We do not know what that buffer is, but I can tell you that some of the areas that we can expand to are based on exigent circumstances. So other than exigent circumstances, they're limited to that particular area.
Mr. Vice Chair, just want to comment too that our new major come from the CIA indicate the CIA as well use the industry best practice standard of 2,000 feet, while we are currently at 1,000. So we're expanding that number to meet the industry best practices.
Further questions from the committee? I'll take more questions offline, but just in terms of a comparison between Maryland State Police jurisdiction and where that's limited to, and then what would this mimic? We can take more of that offline, but I want just to put that in your mind for the next time we talk. All right, thank you very much, Senator Henderson. Thank you. With that, that'll conclude the hearing for Senate Bill 298. We will now move on to Senator Carrozza with Senate Bill 302.
Good afternoon, Mr. Chair and Mr. Vice Chair and members of the distinguished Senate Judicial Proceedings Committee. For the record, Senator Mary Beth Carrozza, representing District 38, Maryland's Coast, which is Worcester, Wycomico, and Somerset counties. And I thank you for allowing me to present Senate Bill 302, which is legislation that would make it a criminal crime causing ingestion of an abortion-inducing drug, a prohibition, and it's been amended as well, and this legislation is known as the Women's Freedom from Coercion Act. I wanted to be clear on what the bill does. It would prohibit a person from knowingly and willfully causing another to ingest, without their consent, an abortion-inducing drug through fraud, coercion, force, or the threat of force when the person knows or believes that the other person is pregnant This legislation recognizes non-consensual or forced ingestion of an abortion-inducing drug is a crime with penalties. A violator is guilty of a felony and on conviction is subject to a discretionary sentence of the judge, which could include imprisonment of not more than 10 years, which is the amendment from 25 to 10 years. I want to be clear. This legislation does not restrict a woman from having an abortion. Senate Bill 302 is narrowly tailored to specifically address an issue on the rise in the United States, the non-consensual ingestion of abortion-inducing drugs. My testimony includes examples of known victims of coercive abortion, highlighting the need to prohibit the forced ingestion of an abortion-inducing drug. This action should be specifically defined crime with penalties to protect women. Now, I'm going to go back a little bit. Some of you may remember Senate Bill 561 of 2019, known as Laura and Reed's Law. Lauren Wallen from Olney, Maryland, was 4 months pregnant when she was killed in September 2017, and her boyfriend was charged with the crime, but he died in his jail cell before the trial began. Laura was killed by her boyfriend because she was pregnant, and she had planned to keep the pregnancy. She had even given her future child the name Reed. Laura and Reed's Law prohibits a person from committing a crime of violence against a woman when the perpetrator knows or believes that the other person is pregnant. Violators are guilty of a felony with a jail sentence up to 10 years, in addition to any other penalty imposed for the crime of violence. The reason I am bringing attention to Senate Bill 561, Laura and Reed's Law from 2019, is to highlight that Senate Bill 302 of 2026 serves a similar purpose. Forcing a pregnant woman to ingest abortion-inducing drugs is an act of domestic violence, and it is a crime. In 2019, we learned that nationally 1 in 10 pregnant women will experience physical abuse at the hands of an intimate partner, and pregnancy-associated homicide in Maryland is 10 times the national average. The Maryland Network Against Domestic Violence reported 237 fatalities due to domestic violence between 2019 and 2023. You all know this because you've heard testimony from others on other bills. Abusive individuals believe they have the right to control and restrict their partner's lives. Forcing a woman to end her pregnancy through fraud, coercion, force, or the threat of force is a form of domestic violence that eliminates her bodily autonomy and her choice. The number of yearly abortions in the U.S. has rose by 10% between 2020 and 2023, and the most common form is abortion-inducing drugs at 64%. This does not include abortions that take place within the home. In Maryland, you can have abortion pills mailed to you if you meet certain requirements, such as having a Maryland address. And while there is no specific information about the number of miscarriages in Maryland, roughly 15 to 20% of pregnancies in the United States end in miscarriage, making this a common complication. If someone were motivated to force a woman to ingest abortion-inducing drugs without her consent, they would have the means and opportunity, and they would also have an alibi by claiming the abortion was just a miscarriage, a naturally occurring phenomenon. Now imagine that you wanted and planned to bring the pregnancy to term, but you thought your own body failed you, resulting in a miscarriage. Imagine the emotional pain and heartbreak you would experience, only to learn that someone took advantage of your trust and poisoned you, ignoring your choice and your bodily autonomy. The reason I'm bringing a sense of urgency to this bill now is that with access to abortion expanded in Maryland, and especially through telehealth and the ready access to abortion drugs, we can expect an increase of coercive and criminal misuse of these abortion drugs. We do not know the exact numbers, as Maryland is one of only 3 states that does not compile nor collect women's health care data, including birth, postpartum care, pregnancy care, and abortion data. Chemical abortion is increasingly marketed as safe, routine, and empowering. But unlike surgical procedures performed in clinical settings, abortion pills can be obtained and administered in isolation, making them a tool for exploitation by third parties. We should be concerned that women who are victims of coercion are being denied informed consent about drugs that could result in their injury or death. Independent research released in 2025 by the Ethics and Public Policy Center demonstrates that complications from the abortion drug, mifepristone, occur at a far higher rates than typically reported. This analysis of over 865,000 insurance claims found serious adverse effects occurred in about 11% of women. We also should be concerned that 44% of abortions nationally are performed on African American women, despite only accounting for 13% of the female population. As a state with a prominent African American population, we can assume that Maryland's percentage would be much higher. I wanted to share with my colleagues that I amended the legislation to reflect the length of the jail sentence established by Lauren Reed's law. Under this legislation, upon conviction of the crime of non-consensual ingestion of an abortion-inducing drug, the person could be subject to imprisonment not exceeding 10 years, again, dropped from the original 25 to 10 years. I believe this new crime and penalty is absolutely necessary for the protection and respect for the autonomy of women experiencing pregnancy in Maryland. The recent deregulation of chemical abortion drugs by the Food and Drug Administration has set up a new crime of opportunity. Until very recently, there were remediation standards requiring that a woman receive a doctor's examination before being prescribed chemical abortion pills. The FDA has weakened these safeguards for this chemical pill. Teleabortion changed that, and now women and others can easily order and purchase these potentially lethal drugs online without ever seeing a doctor. This creates a perfect opportunity for fraud and coercion, so a new crime calls for new penalties. I also want to be clear that Senate Bill 302 would be complaint-driven, meaning the woman herself would have to file charges against a person under this new crime. This committee hears bills on a regular basis that creates a specific crime. In this case, this is justified and even necessary due to recent FDA deregulation and increased online sales of abortion drugs. While Maryland was the first to introduce this legislation in 2025, Louisiana and Arkansas have already passed this important legislation to protect a woman's choice when it comes to pregnancy, and other states have brought this bill forward for consideration. These states now are holding the abusers and perpetrators of domestic violence accountable. And that's what I want to make clear to you, Mr. Chair, Vice Chair, and the members, that the intention of Senate Bill 302 is not to go after the victim, not to go after the providers of abortion, but for Maryland to hold the abusers and perpetrators of domestic violence accountable for the crime of a forced abortion. In summary, Senate Bill 302 prohibits a person from knowingly and willfully causing another to ingest an abortion-inducing drug when that person knows or believes that the other person is pregnant, and without consent through fraud or coercion or through force or threat of force. A person who violates a woman in this manner would be subject to a felony charge and a discretionary sentence of the judge, which could include imprisonment of not more than 10 years. I want to thank the co-sponsors of this legislation on this committee, Senator West, Senator McKay, and Senator Folden, in protecting a woman from being victims of this crime of non-consensual ingestion of abortion-inducing drugs. And Mr. Chair, I'd be happy to work with you in this new area as we bring forth additional information to make the case for why we need Senate Bill 302 as a protection for Maryland women. Thank you, and I have two people on my panel.
Good afternoon, Mr. Chair and members of the committee. My name is Deborah Bricado. I am a retired registered nurse, and I am also a former volunteer of 8 years at a pregnancy resource center. At the center, I heard lots of stories of coercion. There were threats of violence, actual physical violence, and abandonment from boyfriends and family. It was basically get an abortion or get out. There's a new threat to pregnant women. Safeguards for abortion pills have been removed, making it easier for persons with ill intentions to obtain abortion pills and use them against unsuspecting pregnant women. The most significant safeguard removed was the requirement for an in-person exam and a physician. The pills can be prescribed via telehealth, and a physician is not required. Any number of people who don't want the pregnancy to continue could get the drugs. A man could get a woman to get the drugs for him, or because misoprostol is also used for ulcers, a man could get the pills that way. When given correctly, misoprostol and mifepristone are given in doses. The abuser does not care about the correct way to give pills or the risk associated for the woman's health. The abuser is likely to crush the pills and put them in her food and drink, all in one big dose. Giving the pills all at once will cause an even greater level of pain and increase the likelihood of serious injury up to and including death. Adverse events include sepsis, hemorrhaging, infertility, and death. Risks increase the further along the woman is in her pregnancy. She can lose her baby, and she can even lose the ability to have any future children. A new study of over 800,000 women shows that the risk of adverse events is 22 times higher than originally first reported by the FDA. Based on emergency room visits reported to insurance companies, 1 in 10 women will suffer adverse events, I'm almost finished, from the abortion pills. That is just for the women who wanted to take the pills. The Reproductive Freedom Amendment was added to the Maryland Constitution to guarantee a woman's right to make choices about her pregnancy. Violating a right delineated in the Maryland Constitution certainly merits special recognition. This intimate attack on women needs to have a unique designation in the criminal code.
Thank you very much.
So I hope you will support Senate Bill 302 and recognize this threat to women. Thank you.
Thank you very much.
Well, Mr. Chair and members of the committee, my name is Jonathan Alexander. I'm an attorney, and I serve as legislative counsel for the Maryland Family Institute, and I'm offering this testimony to you in favor of SB 302. And I want to do so in sort of an abstract way and then get to the heart of the bill. I want you to imagine for a second a snake handler who deliberately trains a snake to strike a pregnant woman, and he trains that snake to bite the woman in just the right way so that the venom travels to her womb and kills her baby. What should we do with such a man? Well, we would all agree that this is a grave crime and that our law should be able to punish him for intentionally targeting the child that she wants to keep. Well, SB 302 addresses the modern equivalent to that. It's a predator who weaponizes abortion-inducing drugs against a pregnant woman without her knowledge or against her will. You know, 2 weeks ago, even before this hearing was scheduled, I had the opportunity to sit down with a woman named Catherine Herring. And Catherine Herring told me the story of how she was poisoned by her husband 7 times using abortion drugs. He was trying to kill her 3rd baby, and she almost bled out. She got herself to the emergency room. They were able to save the baby. You know, he was able to purchase these pills online. He laced her drinks 7 times. He was convicted, but because there's a gap in the law, the maximum jail time that he got was 180 days. 6 months. 6 months for repeatedly attempting to kill the baby that she wanted in her womb. Well, SB 302 closes that gap. It fixes that gap for Maryland. You know, the Maryland Criminal Code was written at a time where it didn't anticipate telemedicine, and so this updates it. Right now, the code only talks about attempted poisoning or contaminating food. And so there's a gap in the law where if a woman wants a baby and someone else uses the drugs to destroy that life, we can criminalize that perpetrator. Thank you for your consideration.
Thank you very much, Senator, and thank you to the panel. Questions from the committee? Senator Sidnor has a question.
For the gentleman, you're an attorney,
Yes, sir.
and as you were testifying, I was trying to take it all in and just did a quick search. Are you familiar with Criminal Code Section 3214B?
Yes, I'd like your reading of it, just so I'm sure that we're on the same
Says
page.
a person may not knowingly or willfully contaminate, attempt to contaminate, or conspire to contaminate any drink, food product, or food supply by adding disease, germs, bacteria, poison, or poisonous matter.
Okay, yeah.
Do you think that would be applicable to the kind of case that you?
Yeah, very important question. I appreciate it. Mr. Chair, I'll answer that by saying, this was written at a time where you do have a prohibition against, as you mentioned, contaminating drink or food with disease or germs or bodily fluid. That's in the statute that you read. But that targets the woman specifically, and there are other areas of the code too, attempted poisoning, that we could apply in that situation. But it does not address the harm that occurs to the baby within the womb.
So it's not necessarily about poisoning this isn't necessarily about poisoning the woman. It's about what happens to the fetus.
Yeah, it's both. So on one hand, you have, on the one hand, you do have that section that you mentioned about poisoning. On the other hand, you do have fetal homicide statutes, and fetal homicide statutes talk about what happens when someone injures a woman and the baby dies, but that only contemplates things like drunk driving or reckless action that hurts the baby. So you have criminal penalties if you hurt the baby, you have criminal penalties if you hurt the mother by poisoning, but you do not have a statute that brings the two together.
So you believe that there's a gap in law that this bill is trying to fill?
Exactly, and judges have basically asked for, there's a 2025 case here in Maryland where they repeatedly say, hey, we're not removing the woman's right to choose. We're just saying that in an instance where she wants the baby, someone comes in, harms that baby with a particular poison, he is the one that has to suffer the criminal penalties. This fills that gap.
But general law dealing with poison, you're saying it's not sufficient?
Yeah, common law didn't anticipate someone using poison intentionally to harm the baby in the womb.
But again, there's an intentional harm, an intentional act to harm. Even setting aside the baby, an intentional act to harm is criminal.
Yeah,
right.
But it's hard to set aside the baby in this specific instance, and that's what women in this situation are asking for. They're saying, hey, he harmed me. Yeah, it's like a date rape pill or something else that he gave me to ingest. The woman that I mentioned, her husband laced her breakfast water with this colory liquid, and so it affected her. She had diarrhea and cramping, but it also almost forced her to miscarriage, and she had to give an account for that baby that almost died. The baby is thankfully alive now, has some deformities, but it's like, what would have done to that baby, and what criminal penalties can I levy for the life of that baby? She only got 6 months. 180 days in jail.
And 6 months for what were they prosecuted for?
Yeah, as far as they could get was the 7 times that he just poisoned her. There was no attention given to the life in the womb that would have otherwise died, and that was in many ways harmed because of that poison that was intended not just to target her, but intended to target that baby.
So the prosecution was not for attempted murder?
It was not. And in Maryland statute, you wouldn't be able to do that either until we add 302.
Okay, thank you.
Yes, sir.
All right, further questions from the committee? Seeing none, thank you all very much. Thank you, Senator.
Thank you.
With that, that'll be the end of the hearing for Senate Bill 302. We'll now move on to Senator Love with Senate Bill 294.
May I bring up my panel, Mr. Chair? Yes. Thank you. Nope, not this one. Oh, not this one. Sorry. Next. Sorry. Different panel. I'm sorry. Here, you can sit there. Yeah, absolutely. Okay. Is it me? Good afternoon, Mr. Chair, Mr. Vice Chair, Senator West. Sarah Love here to present SB 294, Protecting the Identity of Survivors of Sexual Assault or Stalking. In 2024, Senator Sidner sponsored, this body passed, and the Maryland General Assembly passed, SB 111, Protecting the Identity of Minors Who Were Victims of Crimes. SB 294 builds on that legislation, on that important privacy protection by protecting the identity of sexual assault and stalking victims. Currently, the name of any adult victim of sexual assault or stalking named in a court case is easily accessible to the public. While several entities redact this information, it's still available, especially through public-facing kiosks in courthouses. My Crossfiles office told me they went to a courthouse in every single jurisdiction, and in every kiosk that they went to, they could access the information of sexual assault survivors, private information. So SB 294 would require that the names of sexual assault and stalking victims be automatically redacted from public documents without forcing victims to go through the arduous legal process of petitioning courts to protect their identity. It would still allow defendants and their attorneys to have access to this information, and it would enable a court, upon a showing of clear and convincing evidence, to allow inspection of the unredacted documents. The bill also allows the victim of sexual assault or stalking to petition a court to order redaction of a victim's identifying information from existing records. As we've talked about many times in this committee, we want victims to come forward and identify their attackers so we can bring them to justice. But when faced with the additional threat of having their identity exposed during legal proceedings, survivors may opt to not pursue prosecution because they fear retaliation and harassment. We should be doing everything in our power to ensure that Maryland shields the identity of sexual assault survivors and stalking survivors, and ensure that they are not further victimized while trying to seek justice. SB 294 is important in protecting survivors and also in recognizing that survivors should be the ones who determine whether and when their identity is shared. For these reasons, I respectfully request a favorable report on SB 294. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We are here in strong support of Senate Bill 294. Thank you, Senator Love, for your continued leadership in this issue. On this issue, you know, one of my colleagues says that privacy is like oxygen for survivors of sexual violence. And having done this work for years, I think that's very true. People have had control taken away from them, and they really want to have control over what happens. And there are lots of places in the law that we recognize this. The Violence Against Women Act, we have it in regulations that's all over the place in Maryland's policy to protect survivors' privacy. But there's a gaping hole for criminal cases. So there are all of these filings, including even criminal law 317 requires that the name of the survivor be included in the charging document. So we have this gap. And just at a fundamental level, we should not require survivors to trade privacy for accountability. We should be able to get both privacy and accountability. Two issues have come up that I want to highlight for the committee. The health boards want automatic access to survivors' names to investigate cases where acupuncturists, massage therapists, folks like that have assaulted survivors. We would respectfully object to that. We think that there should be an individualized need assessment, because I think as a practical matter, the courts would require that someone reach out to the survivor and ask them. And that's really what we want. We want survivors to have control of whether some government bureaucrat doing a good thing, but still whether they get their name or not. Second, this has prompted us to re-examine the law, and we're concerned as written, the law is overly broad and really could permit courts to just deny access to a file altogether. We do not want privacy to be used as a tool to protect powerful offenders from public exposure. Accountability is important. So for these reasons, we ask for a favorable report with that minor technical suggestion.
Good afternoon, Mr. Chair, members of the Judicial Proceedings Committee. My name is Mary Setzer, and I'm the head of the Special Victims Unit at the Maryland Office of the State Prosecutor, asking for a favorable report on Senate Bill 294. The Office of the State Prosecutor handles political corruption, police misconduct, and election law cases throughout the state of Maryland. Our office created a Special Victims Unit a few years ago to ensure that justice is served to those who victimize individuals using the power of their public positions. I personally have served as a prosecutor at the local, state, and federal levels, leading prosecutions of domestic violence, human trafficking, and sexual assault. One of the challenges in public corruption cases where there are victims, especially victims of sexual assault and stalking, is the attention these cases receive from the public, a force that often dissuades victims from coming forward. Our office already anonymizes victims' identities during the charging process, but we currently always must advise victims of the possibility of their identity becoming public in filings after the initial charges that are prepared and filed by our office. This legislation would help preserve a victim's anonymity in all paper filings that accompany the case, limiting re-victimization that often occurs when victims lose control of the very personal and traumatic event that they have endured by disclosing it. The exposure of victims' personal details exacerbates the harm they have suffered and has tangible and lasting impacts on their lives. The victims who make these allegations understand that they may still have to appear in court, but it is extremely important that at the charging stage and in filings, their names are not known. This legislation helps ensure that this is a standard practice throughout the state and will be a meaningful way to ensure that victims of these sensitive crimes are not dissuaded from reporting them due to the fear of their identities becoming public. We would like to thank Senator Love for her leadership on this issue, and we encourage a favorable report.
Good afternoon. My name is Sarah Khan. I'm an 18-year-old advocate for sexual assault prevention and survivor protections. I initiated this bill last year with Delegate Guyton, and I'm proud to continue working in strong support of SB 294. When I was 14, I was raped by a boy who I knew was involved in serious criminal activity. My parents immediately began an investigation to build a case against the perpetrator, but I was scared out of my mind, so I made them drop the case. I knew if we pursued legal action that my name would be out there, and if not him, then one of his associates would come after me. I'm grateful that this committee helped to pass SB 111 in 2024 to protect minor victims' privacy. However, this law currently only applies to those under 18. If I were just 4 years older when I had been raped, I would be denied these privacy protections. Last session, Delegate Guyton's office took a trip to every district courthouse and discovered that identifying information of sexual assault and stalking survivors were very easily accessible through public courthouse kiosks, which makes retaliation and exposure that much easier. Sexual assault and stalking cases differ from other criminal cases in that they are sensitive at any age, and retaliation is extremely common. Adult survivors may request anonymity, but it's a long and cumbersome process. Furthermore, in cases of sex crimes, the victim's name is actually required for a valid charging document, which is generally accessible through courthouse kiosks under Criminal Law Statute 3317. 20% of sexual assault survivors do not report their perpetrator due to fear of retaliation. And in workplace settings alone, about 72% of survivors who reported an incident also reported retaliation. So our current system is set up to deter survivors from prosecuting their perpetrators. The government has a duty to ensure the safety of sexual assault and stalking survivors, and part of this is protecting identities to support those who prosecute their offenders. It should be standard policy, not discretionary, that court filings redact identifying information of sexual assault survivors and stalking survivors, both children and adults. Thank you.
Thank you very much, Senator, and thank you to the panel for the testimony. Turn it over to the committee for questions. Before I do, I just want to say, Ms. Khan, thank you for your powerful testimony, but also for your willingness to engage, to change things, to make things better for people that come after you. So just thank you from the committee for your testimony. Senator West.
Thank you, Mr. Chair. I also wanted to thank Ms. Khan for her wonderful testimony. She happens to be one of my interns this year. So it's great to see her actually testifying in the committee for such an important bill. And I thank the sponsor of the bill for bringing the bill. Ms. Jordan, I do have a question for you. The Board of Physicians has asked for an amendment. And let me just read the paragraph explaining why they want the amendment. They say, as currently drafted, the bill would prevent the board's access to identifying information in cases where a licensed physician or an allied health practitioner is the alleged perpetrator of a sexual crime. Without access to victim information, the board could not effectively investigate and administratively prosecute a licensee who may pose a risk to the public. And the amendment that they're asking for is an amendment which would say this section does not apply to a subpoena from a health occupation board in furtherance of an investigation. What is your feeling about that?
Senator, thank you for the question. I think it's important, of course, that physicians in this circumstance be investigated, but I still believe that the survivor really needs to have control over this sort of disclosure, and there's got to be a way to do this. Perhaps there's a way for the Board of Physicians to reach out to the prosecutor's office and the prosecutor send something to the survivor. You know, will you contact the Board of Physicians? Something that is not as open as this doesn't apply at all to this government office. It could even be something in the court file, you know, when the prosecutor interviews the survivor, those sorts of things. I do think that there's a way around this. And actually, I believe the bill really already provides for this by allowing the court to disclose, and would certainly think that if the Board of Physicians asked the court for the information, it would be provided. Now, if I'm incorrect in assuming that there are not millions or hundreds of thousands or even thousands of these cases, and there's some sort of...
The suggestion is there are like 7 a year, but it's 7 physicians who may be abusing women.
7 physicians who may be abusing women is something that the courts could easily handle as a request from the Board of Physicians to disclose this information. And I do think that we should have that additional layer of court review for something as important as privacy. And I think that will facilitate the conversation.
Okay. Thank you for your answer to the question.
Senator.
Thank you. I'd like to push back a little bit, given his question. At that point, I mean, if the state has been involved in the case, you have somebody who's licensed under here who has, I guess, been accused of these types of acts. At that point, I think most of us would find that it's incumbent upon that board to act, and in issuing a subpoena to ensure that they're protecting other people who may be put into that situation. So I just want to make certain that I'm clear. You would be in opposition of that of a subpoena?
I would be in opposition to a subpoena that does not have judicial review. You know, I'm not familiar enough with the Board of Physicians process to know, you know, kind of what's behind the subpoena. I know I have subpoenas that I can issue in basically my drawer, right? So it does seem like this is an important enough issue that we want to have some sort of oversight before a victim's name is disclosed.
Thank you.
All right, additional questions from the committee? All right, thank you all very much. Thank you. With that, that will conclude the hearing and the testimony for Senate Bill 294. We'll now move on to Senator Love with Senate Bill 334.
Where is the chief? Maybe outside. We're looking for Chief Miguez. Okay. While we're waiting for her, may I start, Mr. Chair?
Sure, absolutely.
Thank you so much. Chair Smith, members of Judicial Proceedings, Sarah Love here to present to you SB 334, addressing what are essentially DIY, do-it-yourself machine guns. Now, what do I mean by DIY machine guns? I'm talking about pistols that are easily converted into fully automatic weapons by using a small, quarter-sized
pistol converter, also known as a switch. These machine guns are capable of firing up to 20 rounds per second with a single pull of the trigger. As stated by the Baltimore Police Department in their letter of support, quote, "The danger posed by a firearm modified in this manner is difficult to overstate," end quote. Once the trigger is depressed on one of these firearms, it will continue to fire up to 1,200 rounds per minute until there is no more ammunition or the finger is taken off the trigger. The Baltimore Police Department has identified the use of firearms modified with switches as a significant and ongoing public safety threat in Baltimore. In 2025, the BPD, in coordination with the Drug Enforcement Administration, dismantled a major drug trafficking organization. 9 handguns were seized, including 3 that had been converted into fully automatic machine guns. In 2025, in Philadelphia, someone used a DIY machine gun to kill 2 people and wound at least 9 others, including teenagers, on Memorial Day in a park. In 2024 at Tuskegee University, a DIY machine gun was used to, and quote, "a hail of gunfire," quote, left 1 man dead and 16 injured. Here in Maryland in 2023 at Morgan State University, 5 people were injured by a DIY machine gun. These are just a few of the many examples of what we're talking about. Machine guns are illegal under federal and state law. So are switches. But law enforcement across the country and across our state are recovering these DIY machine guns at increasing rates. Due to the growth of 3D printing and traffickers who smuggle and sell them, switches are cheap and easy to get. ATF data shows that recoveries of machine gun conversion devices increased by 784% from 2019 to 2023 alone. Maryland law enforcement are also recovering these converted pistols at increasing rates, as you will hear in just a minute. The majority of gun manufacturers use designs that are not easily convertible to machine guns, but several do. And while these manufacturers should be taking steps to make sure their guns aren't easily converted into DIY machine guns, they have not. And that is why we need SB 334 to strengthen product safety standards for all handguns sold in Maryland, ensuring that no handgun is sold to civilians that can be easily converted into a DIY machine gun. So what does SB 334 do? It adds machine gun convertible pistol to our current law addressing assault weapons. What does SB 334 not do? It does not require current owners to modify or get rid of the convertible pistols that they already own. It does not bar future sales to law enforcement officers or agencies or to members of the military acting within the scope of their official business. It does not treat dealers unfairly. The bill has a delayed effective date so that existing inventory can be sold. It does not target responsible gun owners. It targets industry designs that make machine gun conversion possible in the first place. And I want to close with something that happened just a couple months ago. There was a triple shooting in Indianapolis. Fox 59 reported that, quote, "in the span of just 2 seconds, more than 40 gunshots were unloaded by 2 handguns equipped with machine gun conversion devices. The volley of gunfire left 3 people wounded and damaged multiple cars. They pull the trigger once and it sprays everywhere. It sprays rounds everywhere," said Indianapolis Metro PD Lieutenant Jared Heidelbaugh. "They are proliferating in this community, and we're not going to get all of them. It's impossible to get all of them," said Heidelbaugh. In your packet, you have many, many letters of support for this bill, from law enforcement, elected officials, advocates, and everyday citizens. I urge you to read them. Maryland can and should protect our residents and our law enforcement from these DIY machine guns. And for these reasons, I respectfully request a favorable report on SB 334. Thank you.
Good afternoon, Chair Smith and members of the committee. My name is Mary Kanaa, Policy Counsel for Everytown for Gun Safety. On behalf of Everytown, I urge a favorable report on Senate Bill 334. This bill would prohibit the future sale of semi-automatic pistols that are easily convertible into illegal machine guns. It goes without saying that machine guns are exceptionally lethal weapons meant to inflict maximum damage in minimum time. Machine guns are illegal under federal and state law, but certain types of pistols can be easily converted into DIY machine guns at home, even by people with little to no engineering skill, using only common household tools like a screwdriver and a small piece of plastic or metal commonly known as a Glock switch. DIY machine guns are extremely dangerous and are spreading throughout Maryland. They can fire at a rate of 20 rounds per second, allowing shooters to spray bullets with a single pull of the trigger and little control. Every firearm manufacturer should be taking steps to make sure their guns can't easily be converted into machine guns, but that's not what is happening. Despite the explosion of a market for illegal pistol converters and an uptick in crimes committed using fully automatic modified pistols, a small number of gun manufacturers, including Glock and others, continue to offer machine gun convertible pistols to the civilian retail market. While Glock recently introduced new models with some small design changes, it appears that even with these changes, its pistols remain easy to quickly convert into illegal machine guns with common household tools and a Glock switch. The manufacturers using this design have the ability to stop the spread of DIY machine guns. They have chosen not to, putting profit over people. We need to address gun violence from every angle, including by removing these dangerous weapons from the marketplace until manufacturers change their design so that they cannot easily be converted into machine guns. Thank you for your time. I look forward to your questions.
Mr. Chairman, Vice Chairman, and members of the committee, my name is Amy Miguez, and I'm the Acting Chief of the Annapolis Police Department. I'm expressing our strong support for Senate Bill 334 that will require all handguns sold in Maryland to be designed in a way they cannot quickly and easily be turned into machine guns. Annapolis is unfortunately familiar with the occurrence of gun violence. In fact, yesterday afternoon, a disagreement led to multiple shots being fired, an adult male victim seriously injured in a stabbing. Thankfully, the victim is in stable condition, and we were able to arrest the two suspects and recover the handgun believed to have been used in the attempted homicide. While this incident did not involve a handgun that can easily be turned into a machine gun, Annapolis has experienced shootings involving these types of handguns, including shootings with a pistol converter installed and recovered handguns with pistol converters installed. We know that some of our shootings and shots fired calls have involved handguns with a pistol converter installed simply due to the large number of shell casings recovered at the areas where the shootings occurred. Since January 2023, we have had 8 separate incidents where 30 or more shell casings were recovered. In 2024, Anne Arundel County Police Department recovered a handgun with a pistol converter installed that was confirmed to have been used in a shots fired incident in Annapolis. Also, as recently as August of 2025, we recovered a handgun used in a double shooting that had a pistol converter installed. In that case, we were investigating the non-fatal shooting of 2 adult male victims that were shot while standing in a parking lot of a residential neighborhood. Our officers were able to identify the suspect in the shooting and obtain a search warrant where the gun used in the shooting was recovered. Data from Maryland law enforcement agencies shows that 45.5% of handguns recovered by law enforcement with pistol converters installed were subsequently linked to shootings already committed through the National Integrated Ballistic Information Network, or NIBIN. For these reasons, the Annapolis Police Department respectfully supports Senate Bill 334 and urges the Judicial Proceedings Committee to give it a favorable consideration. Thank you.
Mr. Chair and members of the committee, thank you for the opportunity to testify today in support of this legislation. My name is Greg Lickenbrock, and I'm the Senior Firearms Analyst for Everytown for Gun Safety. Before joining Everytown, I spent a decade working in the gun industry as a magazine editor. I tested hundreds of firearms, attended media events and training courses, and met people working at every level of the industry. I also worked extensively with Glock and its products. Federal and state law prohibit civilians from owning machine guns and the parts used to create them, but switches have made it extremely easy for people to convert Glock-style pistols into machine guns that can fire 20 rounds per second. These switches are tiny, easy to buy online or 3D print, and difficult for police to intercept. Glock-style pistols are uniquely easy to convert with switches. It takes less than a minute to install one because they use cross-shaped or cruciform trigger bars that provide surface area for a switch to contact. Each time the gun's slide returns forward, the switch hits the trigger bar, pushing it downward, causing the gun to fire. As long as the shooter depresses the trigger and the gun has ammunition, it will continue firing. This kind of rapid fire has already devastated many communities, as guns with switches have been used in at least 20 mass shootings across the U.S., and they've also been recovered all over Maryland. But this problem is fixable. The only pistols compatible with switches are those that use Glock-style trigger bars, that cruciform trigger bar that I mentioned, including Glocks, Glock clones designed to capitalize, Glocks and Glock clones designed to capitalize on the company's expired patents and market share, like the Ruger RXM and pistols made by several smaller companies. Other pistols made by the largest manufacturers, including Smith & Wesson and Sig Sauer, are incompatible with switches because their trigger bars are broken into smaller, disparate components that are shielded from interference. This is why I believe this bill offers a smart, targeted approach to solving this problem, and gun owners would continue to own, they'd be able to keep the guns that they currently own. I respectfully ask you to stand up for public safety and pass this bill. Thank you.
All right, thank you very much for the testimony. We turn over to the committee for questions. Senator West.
Thank you, Mr. Chair. I guess my question's for the sponsor of the bill. I've been listening to the testimony, also racing through the opposition, and there is one opposition which contains a couple of sentences which I want to read to you and ask you to respond to them. What this says, it says, illegal possession and or misuse of Glocks and such devices in a violent crime are serious crimes under existing state law. Persons who are willing to violate these existing laws will not be deterred by this bill from acquiring Glocks from out-of-state sources and bringing these firearms into Maryland. So what he's saying is right now, if somebody modifies a Glock so it turns into a machine gun and uses it illegally in the state, that's violation of a federal crime, and I think it says it's a felony under federal law. So if someone's willing to commit a felony under federal law, what in this bill would deter such a person from acquiring a Glock in another state and bringing it into Maryland to commit the felony here?
Thank you for the question, Senator. The goal of this bill is common sense design regulations. What we want to happen is for these manufacturers to change their designs so that it is not so easy to get these easily converted pistols. You're right, someone with criminal intent will find a way, but that doesn't mean we should make it so easy for them to do it.
Okay, thank you for your answer.
Further questions from the committee? I have one for Greg. I mean, and it's kind of it follows on to what the senator just said about the design. And you mentioned a couple of other models. So this, we're talking about the Glock right now. But if we were to go ahead and pass this piece of legislation, why is this not applicable to? Why are other firearms, like you mentioned the Ruger, and you talked about Smith & Wesson, like are they as susceptible to this design flaw or augmentation that we've tried to outlaw and that we've done through litigation, we've done through legislation? It just keeps evolving. So can you tell me a little bit why this is a particularly susceptible model to this?
Sure. Thank you, Mr. Chairman. That's a great question. So this bill would affect a very small, narrow section of the striker-fired pistol market because the cruciform trigger bar provides so much surface area for a switch or pistol converter to hit an impact. Virtually every other pistol that does not use a cruciform trigger bar can't be converted with a switch, and that's the design intent here. So I would say roughly 75 to 80% of the pistol market would simply be untouched by this bill because those guns do not use cruciform trigger bars, and they have shielded their trigger bars from the rear so that you couldn't simply attach a switch to a slide and have a fully automatic weapon.
Can you explain to the committee again what the trigger bar is, where it's located, and what it's shaped like? I know
Yes.
I've seen, we've actually had discussions about this, so I've seen some of the diagrams, but could you just help the committee understand
Sure.
where this is?
Yes, I'll try my best.
I know
So
it's
a cruciform trigger bar is it looks
level,
like
yeah.
a long sliver of metal inside the gun. It's attached from the trigger, and all it does is as you pull the trigger to the rear, this flat piece of metal that has a cross shape towards the end, that's why it's called a cruciform trigger bar, it moves to the rear, and then eventually it drops away from the firing pin, allowing the gun to fire. That design itself is very unique to Glock's. It was actually patented by Glock, and that patent expired in 2015, I believe, which is when switches really became a problem. Other companies began using that same trigger design, the cruciform trigger bar, in their pistols in an attempt to capitalize on the Glock market for handguns.
All right, thanks. Any further questions from the committee? Mary, I'll ask a question. A question for you then. We've had a lot, again, our efforts have kind of chased what Supreme Court precedent has set forth, and we've had a pretty groundbreaking Supreme Court case under Bruin, which I thought was perplexing, but nonetheless, it was a decision that came down. We've got to deal with that new reality through legislation. And we've passed, in the last couple of years, legislation for sensitive locations and obviously gun industry liability. So we've done, a lot of things recently upheld with and then the Fourth Circuit. So we're in a good spot here. But how does this, if we were to pass this, how do you think this would comport with the legislative or the legal landscape under Bruin, if we were to go ahead and push this through?
Well, to your point, the Fourth Circuit recently upheld Maryland's assault weapons law. This is like an adjustment to that law. It's an addition to that law, and the Supreme Court denied cert in that case, so they're letting that decision stand, and they're letting the assault weapons law stand as it is. And then under the Bruin analysis, I would say it's constitutional for the same reason that other safety features laws are constitutional. Not being easily convertible into a machine gun is just as much of a safety feature as, for example, a chamber-loaded indicator, which is required under Massachusetts and California law. At the textual step, banning the sale of these guns does not meaningfully constrain anyone's ability to keep or bear arms because they can keep or bear a non-machine gun convertible pistol. And at the history step, we can make analogies to firearm and gunpowder storage laws, trap gun restrictions, or especially dangerous weapons laws, which again goes to the upholding of the assault weapons law. So I think that answers your question.
Thank you, Mr. Chair. Mary, I had to step out for a moment, so if this was answered in a previous question, please let me know. But I heard you talking about Bruin, but the court has taken steps since Bruin to make clear exactly what they meant in that case, specifically in Rahimi. I know the Fourth Circuit was referenced at all. I know Rahimi isn't specifically factually on point, but just philosophically, where has the court gone since Bruin as evidenced by Rahimi and some of the lower court cases in which they have not granted cert?
Yes, like you said in Rahimi, although domestic violence wasn't necessarily a concept at the founding or during Reconstruction, they upheld the restriction on people with domestic violence restraining orders from owning handguns and owning any guns. So they see that there are limitations to this purely historical context analysis. And to your point, the Fourth Circuit upheld Maryland's assault weapons law, and in fact, every assault weapons law in the country that has gone to an appeals court has been upheld. So we can see that these laws that are regulating dangerous weapons, particularly dangerous weapons, like assault weapons, like machine guns, have been upheld by courts across the country.
Just a quick follow-up. Here's what I hear you saying. I think there was a perception after Bruin that Bruin was a fairly absolutist decision. And is it fair to say that perhaps what has happened in our courts since Bruin is less absolutist than we perceived it to be on both sides of the ideological divide after the opinion was written?
Yeah, I would say that that's correct. I think that we've seen from the Supreme Court denying cert in other cases, allowing gun regulations to stand, that Bruin doesn't mean that there can't be any regulation on firearm ownership, firearm purchases, et cetera.
All right, excellent. Further questions from the committee for this panel? All right, Senator, thank you all very much. Thank you. All right. All right, let's hear is Councilmember Fisher, Councilwoman Fisher, Wanika Fisher. Laura Johnny English. Crystal Gonzalez.
Good afternoon, everyone. Good afternoon, Mr. Chair, Vice Chair, and distinguished members of the committee. My name is Crystal Gonzalez, and I am here today to offer testimony on behalf of the Maryland chapter of Moms Demand Action as a survivor. I am the mother of a child whose life was prematurely taken by gun violence. And when you lose a child, something breaks on the inside of you that can never be put back the same. I often say we can't bring them back. That's the one thing we want the most, but we can bring them with. We bring our children with us through the work that we do, through the hearts that we help to heal, and through the communities that we help to restore. We bring our children with us, and today I bring my child, Aaliyah Gonzalez, into this room. Because this conversation, the bill, your votes, they're real to us. They sit in our homes, they sit at our dinner tables with empty chairs. They show up in our communities as trauma, fear, and silence. The facts speak for themselves. A switch is a small, often undetectable device that transforms a semi-automatic handgun into a weapon capable of firing 20 rounds per second. The use of these devices have grown exponentially in recent years, and too often, families like my own who are affected by violence are often left to heal alone, to navigate systems alone, and to rebuild their lives alone, while the very conditions that caused harm in the first place, those conditions remain unchanged. But that's where you all come in. This bill is a measured, targeted approach to preventing proliferation of weapons that can be easily converted into fully automatic firearms. We often hear phrases like bullets have no name, or my favorite, wrong place, wrong time. And I want to be very clear today, our children are not in the wrong place at the wrong time. They are often in the right place at the right time, learning, growing, and becoming who they were meant to be. It is violence that has no place in our schools or our communities. I did not choose this journey. Lord knows I did not. There's a billion other things I'd rather be doing. As a matter of fact, I just want to be home with my daughter. But unfortunately, I cannot have that. So what I choose instead is to transform my everyday grief into my survivor power. I urge this committee to give this bill a favorable report and help Maryland take this important step forward, protecting our communities from weapons that have no place in civilian hands. Thank you for your time and consideration. Thank you.
Good evening. My name is Lauren Johnny English. Most people know me as AJ. I'm a sophomore at Watkinsville High School, that's in Montgomery County, and I am a Students Demand Action volunteer, and you can see there are a lot of moms behind me today. I am only 14 years old. I should be worried about homework, about sports, about what I want to be when I grow up, but not whether I'll make it home alive. But this is the reality that my generation is living in. Machine guns are illegal in Maryland, and they're supposed to be off our streets. And yet they keep showing up because the gun industry yet again found a loophole. We call them DIY machine guns, as you saw. They start as regular pistols, but they can be converted into fully automatic weapons with a tiny Lego-sized device called a switch. They can fire up to 1,200 rounds per minute. That terrifies me, and that should never be possible. The switches themselves are already illegal, but are 3D printable and flooding our communities. At Watkinsville alone, within the past 4 years, we've had numerous gun threats. It's terrifying. Guns are the leading cause of death for children and teens in Maryland. Most young people who die by guns are killed by someone else. So while gun manufacturers' profit continue to go up, we live in fear of our lives being cut short every day. This bill does not take away from gun responsible owners. It does not punish responsible dealers or target law enforcement or the military. It does one simple, common sense thing. It stops the sale of handguns that can be easily turned into illegal machine guns. 84% of Maryland voters support requiring manufacturers to design pistols so they cannot be turned into fully automatic machine guns. We should never have, and we should never again have to wait for another tragedy to make this obvious. I am tired of looking at the news every other day on my phone and seeing my generation ripped apart. We deserve prevention and we deserve accountability. We ask of our legislators to please deliver a decision in favor of SB 334 for students like me and for the future we're trying hard enough to survive to reach. Thank you.
Excellent. Thank you very much for that testimony. Thank you, AJ. Are there questions from the committee for the last two panelists? All right, so we're now going to switch to the panelists who are joining us virtually, and we'll start off with Mr. Rosenberg. You're up. Welcome.
Thank you. Good afternoon, members of the committee. I'm Adam Rosenberg, the Vice President of Violence Intervention and Prevention for LifeBridge Health and the Executive Director of our Center for Hope, our comprehensive response to violence. I testified today in strong support of Senate Bill 334, thanking our sponsors, Senators Love, Smith, and Waldstreicher. As a representative of our health system, I've spent my career helping keep kids safe. We know with a public health challenge such as child fatalities, we have to take a multi-pronged approach to prevent death. One such example has been preventing automobile deaths for kids, for example. Car seats were required in 1985, airbags were required in 1998, and personally being the parent of twins born in 2003, thankfully latch laws were required to make all cars manufactured after that, making it much easier to put a car seat in. All of this has reduced child fatalities in automobiles dramatically. Ironically, so much so that gun deaths now exceed automobile deaths among children and teens in the United States since 2020. In no other comparable country are firearms within the top 4 causes of mortality among children. With Senate Bill 334, we employ that same logic and that same public health approach to prevent future gun deaths. By requiring necessary modifications to an existing product to save lives and prevent future harm. When you have a public health crisis, it's about having everyone you can take action. There's more we can do than helping those shot here. Everyone who can be part of the solution needs to play a part. We know pistol converter switches are a clear and present threat. This is a now problem, and we want companies to step up and ensure their designs protect us as well. Just as we have repeatedly required automobile manufacturers to update their cars and their designs to save lives. We need to act to take measures to prevent designs which are being widely converted into instruments of fatality. We've created accountability around the use of a pistol converter and the creation of a pistol converter. What we're saying here is we want to make this as hard as possible to convert a pistol to a machine gun to prevent future fatalities. Thank you all.
Excellent. Thank you very much, Mr. Rosenberg. We'll now switch over to Layla Gretton. You're up. Welcome.
Thank you. Thank you, Chair Smith, Vice Chair Waldstreicher, and esteemed members of the Senate Judicial Proceedings Committee. My name is Layla Gretton. I'm a high school student at Archbishop Spalding and the founder of a local Team Enough chapter, a youth-led initiative under Brady United. I'm speaking today to voice my support for Senate Bill 334. As the president of Team Enough Baltimore, I oversee nearly 50 students with a shared passion and commitment to gun violence prevention. DIY machine guns disproportionately affect my generation, as the majority of the individuals thought to be connected to incidents with a modified gun are under the age of 21. My generation has been impacted the most by this crisis. Young people are both the primary victims and perpetrators. The accessibility of these deadly weapons, combined with inadequate education and intervention, has created a dangerous cycle. And without urgent action, more of these convertible pistols will fall into the hands of Maryland's youth, enacting even more of a toll on our society. As a young student, I decided to conduct a quick experiment to see how accessible it would be for someone in my generation to modify a firearm. It took me 2 Google searches to find a list of easily modified guns. Only a few more to end up on pages where people post details about how to modify these pistols, and even pages where people post the 3D printer designs needed. The entire search process took me less than 10 minutes, emphasizing the accessibility of these deadly features and how easy it could be for a violent individual to go down this route. Thankfully, there is a solution, and those are easy to sign changes. And it is the responsibility, of the firearm manufacturers to take this action. The companies are aware of the convertible nature of their firearms and have chosen not to make design changes. This industry rakes in billions in profits every year, while our communities and students reap the consequences. By allowing for the installation of illegal modifications, it is evident that these industries are more focused on prioritizing profits than public safety. And as Marylanders, we must take a stand to protect our communities and students and save countless lives. Therefore, I strongly urge a favorable report for Senate Bill 334. Thank you.
Thank you very much, Layla. All right, we'll now go on to Mr. O'Brien. Welcome.
Thank you, sir. Chair, members of the committee, thank you for the opportunity to speak in support of Senate Bill 334. My name is John O'Brien. I serve as the director of the Montgomery County Police Department's Special Investigations Division. Our division is responsible for investigating firearms-related offenses, among other serious crimes. This bill addresses a growing and dangerous loophole in our firearms laws: the rise of machine gun converted pistols. These are semi-automatic handguns that can be easily transformed, often with 3D printed and done in mere minutes. Once converted, these handguns can fire dozens of rounds in seconds, turning a concealable handgun into a weapon of mass violence. We've seen the tragic consequences of these rapid-fire devices across the country. They dramatically increase the lethality of shootings, endanger law enforcement, and put innocent lives at risk. In Montgomery County alone, over the past 4 years, we've investigated 528 handgun shooting incidents, an average of 132 per year. During that same period, our department has seized 27 handguns that have been modified, including 12 in the last year alone, which represents a 70% increase from the previous year. Senate Bill 334 is a critical step for preventing these dangerous modifications. I urge you to support this legislation and help keep Maryland safe. Thank you.
Thank you very much. All right, we'll now move on to Mr. Segura.
Hello, Chair Smith, Vice Chair Waldstreicher, and members of the Senate Judicial Proceedings Committee. My name is Daniel Segura, State Policy Manager for the Brady Campaign Against Gun Violence. Brady is proud to support SB 334, which provides a strong defense against the proliferation and dangerous impact of DIY machine guns throughout the state of Maryland. SB 334 will protect Marylanders from DIY machine guns by prohibiting the future sale of any pistol that can quickly and easily be converted into a machine gun by attaching an auto sear, commonly known as a Glock switch. This will help hold the industry accountable by requiring companies that design their pistols to easily accept these devices to stop selling them to civilians unless and until they fix the problem. DIY machine guns are a growing threat to public safety. Fully automatic machine guns have been illegal under federal and Maryland law for decades, but they can be made at home by attaching an auto sear, which is a tiny piece of metal or plastic, to a convertible pistol. Shootings committed with these modified fully automatic handguns have been significantly more deadly since they allow the shooters to spray bullets with a single pull of the trigger, endangering bystanders. In 2023, a pistol converted into a machine gun was used during a shooting that injured 5 people at Morgan State University, and in Baltimore alone in 2024, police recovered 65 modified pistols. These DIY machine guns are flooding Maryland because gun manufacturers have manufactured their pistols in a way that makes them uniquely easy to convert into machine guns by attaching the autoseer. Because these companies choose profits over public safety, anyone with one of these pistols, an autoseer, and a screwdriver can turn their pistol into an illegal and extremely lethal machine gun in just a few minutes. The firearm industry has known about this problem for years, but has not taken responsibility for its easily convertible products and has instead refused to take serious action to fix its design. As long as Maryland gun dealers are selling pistols that can quickly and easily be turned into machine guns, this public safety threat will continue. SB 334 solves this problem, and I urge the committee to favorably report on this measure. Thank you for your time.
Thank you very much. All right, questions from the committee for the panelists joining us virtually? All right, seeing none, thank you all very much. With that, that will conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, which I'll bring up Mark Pennick, John Jocelyn, Mr. Pica. Is John Pica here? And Carla Mooney. Welcome.
Thank you, Mr. Chairman. Mark Pennick, President of Maryland Shall Issue. I'll be the person not to defend Glock switches or converted pistols. As far as I'm concerned, you can make possession of a Glock converter into a major federal felony with a life sentence. But what you can't do under the Second Amendment and under common sense is penalize a manufacturer who makes an otherwise perfectly lawful firearm, and then punish that manufacturer because a criminal is illegally converting that lawful device into an illegal item. Under Maryland law, that has never been the case. This would be the first time that I know of where a bill has been enacted that punishes a manufacturer because of a criminal action to actually change the structure. And yes, it has to be changed. They have to cut a notch. They have to install something. The bill, you heard from the sponsor, that will even include the latest models produced by Glock, Glock B series and Glock Gen 6, which were specifically designed to defeat switches, but still use a cruciform trigger bar, because that is essential to the safety mechanisms of the Glock pistol and the Glock design. You're basically telling the Glock that they can no longer use the very device that makes the Glock safe. Now, I will say for certain that the bill, if enacted, will be challenged. But it's not just against Glock. You can convert every single striker-fired pistol into a fully automatic. My written testimony has a link to a Sig Sauer M17 that was done. And it is equally applicable because to every single trigger striker-fired pistol, because they all can be accessible. There is no trigger bar that is shielded from interference. None. So just like that Sig Sauer was converted, you can convert any one of those into the same thing. Thank you.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking for 2A Maryland in opposition to Senate Bill 334. Heard some interesting comments today. What we didn't hear is how many of these pistols were being used by persons who were already prohibited from owning a firearm to begin with, regardless of any modification. It's been admitted that we've banned all the switches, all devices, Hellfire, rapid fire, auto switch, all of this, banned by Maryland law, banned by federal law. Now we want to ban the pistol itself. So what we've done is we've taken the most popular and perhaps safest pistol in America and vilified it because someone can do something wrong with it. You heard a lot about DIY and Google and 3D printing. What would make anyone think that this bill would suddenly stop Google, 3D printers, do it yourself? It would simply create a stronger market. The bill prohibits the transfer of a firearm or the receipt of a firearm. That means myself, as a state police certified instructor and Glock armorer, I cannot take my hand and hold someone else's Glock. They can't take mine. We're looking at 3 years. Much ado about the crucible trigger bar. This is what it looks like. For those of you who've never seen one, but you're all hyper about it, this is what it is, a little tiny piece of metal. Makes the pistol one of the safest pistols in the world. It is almost impossible for an accidental discharge to occur because of this design. It's ingenious. Can it be abused? Yes, it can. But then anything can. My hand that I've saved lives with as a first responder can go from this hand that's a lifesaver to this hand that's a weapon. It all goes to personal choice what I do. Am I a law-abiding, honest citizen, or am I a criminal? We know the criminals don't obey the law. They won't care. We, the law-abiding citizens, are now having policy dictated to us by the criminals. Thank you.
Hello, Mr. Chairman and members of the committee. John Pica on behalf of National Shooting Sports Foundation, the nation's trade association for the firearm industry. Based on market share of Glock pistols among the civilian population, Glock has about 35% market share. There are roughly 1.2 million law-abiding gun owners in Maryland. You might be making at least 400,000 people criminals with the passage of this bill. So yeah, I would suggest if someone commits a crime with this bill, there should be some kind of mandatory penalty for them. But it doesn't make sense to make law-abiding citizens criminals. We would ask for an unfavorable report, sir. Thank you.
Good afternoon, Chairman of the committee. My name is Carla Mooney. I'm here representing Women for Gun Rights. I look at this bill as another reason for a self-defense tool to be taken off the market, something that's easy and common in use. I feel like the criminal never follows what the law says, and we already know that everything that we're trying to criminalize here is against the law. The switch is against the law. The murder is against the law. Having a firearm when you're a felon is against the law. I don't believe that this law has anything to do with protecting our people when self-defense tools are being taken away. I'm a firearms instructor. I've taught a lot of people, and a lot of those people that I've taught to defend their own lives use a Glock. It's not one of my favorites, but that doesn't mean it's not usable and acceptable as a self-defense tool. I do not believe this bill will help protect us and keep us safe. I believe that this is just one of many attempts at a feel-good bill. I ask for an unfavorable report on this bill.
Thank you very much for your testimony. We have a couple questions from the committee. We're going to start off with Senator James.
Thank you, Mr. Chairman. Unfortunately, I was out of the hearing room conducting an interview for my other capacities on exec nom. So crucially, I did not hear the vast majority of the plaintiffs, the opponents. However, we had a very helpful conversation yesterday. Thank goodness we did. But now I'm in a state of confusion because maybe I didn't ask all the right questions of the subject matter experts. But it really caught my attention that the two of you, you too, indicated a few things that I don't think I appreciated. So let me understand this, that right now, Glock sells a totally lawful firearm, but they are not selling this small item that we're describing and is the subject of this bill. They're not selling that which allows it to turn into a, an automatic, machine gun and pistol. Is that what I just understood?
So as of November 30th, 2025, okay, Glock discontinued the distribution of Glock's 3, 4, and 5 generations. And are now distributing.
Pistol or this
That's
device?
The pistol. Okay, that's the pistol. Okay, those are the ones that existing switches work with. So those are no longer being sold by Glock. Instead, they have redesigned the Glock pistol in an effort to meet objections like this one. And they're called the B series and the Gen 6. And they have been redesigned to slide in an effort to defeat Glock switches by introducing metal into the slides that would prohibit Glock switches from being used in that capacity.
Thank you. Let me just make sure I understand something fundamental first before you go on. But at the time before the B series and the Gen 6 series, Glock not only sold the pistol at issue, but the device that allowed it to go to a
Never.
fully.
No.
It was never something that Glock sold. Okay, I misunderstood this from talking to other people.
The switches are illegal from the start. It's a felony under federal law. It's a 10-year felony. It's illegal under state law, existing state law. So the mere possession of a switch will get you sent away for a long time.
Only because I heard you say Glock switches, so then I'm like, maybe we shouldn't say that because that confuses a layperson.
In fact,
like me.
well, the counterfeiters
Sorry.
often put Glock's logo and the name on these switches in an effort to sell them, but they're illegal from the outset. I don't think anybody disputes that.
And then, if I understood the collective testimony of all of you, not only does Glock sell a pistol that is capable of being converted, or did easily allow for conversion prior to this redesign, but other gun manufacturers have other pistols that are likewise vulnerable, easily vulnerable to a mechanism that can turn it to a mini machine gun.
So
Is that correct?
there's two classes of pistols. The greater class is striker-fired pistols.
Sorry, say that again?
The greater class is striker-fired pistols.
Okay.
And they don't use a hammer. That's the easiest way to distinguish those.
Okay.
So there's a whole bunch of manufacturers of striker-fired pistols, including Sig Sauer, with Smith & Wesson, Walter PPH. There's just a host of them.
Okay.
So Glock's are striker-fired pistols. Glock uses a particular form of its design, uses a cruciform bar, trigger bar, and its design. That makes the Glock pistol safe.
Okay, and why does it make it safe, sir?
Because it interferes with a negligent discharge of a drop pistol or a pistol that is actually mishandled in such a way that causes the striker to come forward with a spring fire.
So that mechanism, as good as it is for safety purposes of not having an unexpected discharge, but also, not intentionally by Glock, also made it vulnerable to the illegal conduct of others to use something about this design that they can also use it to turn it into
So in order for the switch to work, somebody has to take a file to the frame and cut a notch in it. In my written testimony, you will see an actual photograph of that notch.
I'll look at that for sure.
And that notch is a conversion of the frame itself.
Okay.
Glock has made that more difficult with some of the latest series that it has by doing metal frames. So, and they have to then remove the back plate of the slide and insert the Glock switch, which is illegal to own in the first place.
Well, apparently people know how to do that pretty easily.
Yeah, it's not hard.
Yeah,
So Glock, in an effort to address that, has released these new models and discontinued the distribution of existing models. And you heard from the sponsor that they want to have this bill applied to those new models as well. Well, that basically requires Glock to abandon its cruciform bar, trigger bar, and that makes the Glock less safe.
It's sort of like what, that may be true, but then apparently that very thing makes it more safe for unexpected discharge, but more unsafe for the ability of bad actors to convert it to a machine gun.
It's really just a matter of a slight degree, because you can convert any striker-fired pistol into a full automobile.
Well, I don't know if it's in your testimony, but if you are aware of this, I'd like to have your data and anybody else's data on sort of how many people are doing this with other firearms, other striker pistols.
You have
that are just as vulnerable and just as easily turned into these little machine guns.
It's a matter of degree of how vulnerable it is. It's certainly,
Well,
the bill says readily
It
convert.
implies something that I want to understand with data. That's
I don't have the data for you.
No,
I'm sorry.
you don't have it now, but you said it, so.
readily convert can apply to any striker-powered pistol
I
at
said
all.
easily.
That's the problem with the bill. Readily convert is, one, not defined. Use of common tools, people can make that into a 6-hour M17, the latest version. You could do the same thing with all the rest of them. So this basically bans a whole class of pistols, which is really going to be hard to defend when I challenge this bill in court.
And yeah, thank you. And I'm learning a lot, so I really want everybody to follow up with me and give me more information so I can sort this through. But I just, in addition to the question I just asked you, you're not gun manufacturers, but you have some knowledge. So I'm curious about the Glock company and the other companies that make striker pistols that are likewise able to be converted into these mini machine gun. Are they exploring now a way to keep the safety that they find desirable, and others do, of not having it, automatically discharged, but address the real problem with, because just as a gentleman earlier talked about, we insist that cars be made safer, right? We insist on it. So in a way, we're trying to insist that gun manufacturers take into account the real facts that this can happen, even if widespread or not. So I'd like to know if they're working on some technology. They're very innovative. They have a lot of money to make these guns. This problem go, less.
So the basic problem is that any semi-automatic pistol can be converted into a full auto by this very neat, any semi-automatic pistol. That includes a Colt 1911, which this bill excludes because it excludes hammer-fired pistols. But that at least recognizes that there's less, that's less susceptible to that. But it can be.
Many things can be converted, but what I'm trying to find, I saw a video, it was authentic, of law enforcement using this particular older Glock and what it was like when it was in semi-automatic state and what had happened when, this converter thing was done. And it is shocking. It's
Absolutely.
shocking in the speed and severity of
It's a machine gun.
So I don't think anybody, reasonable person, wouldn't try to figure out every way we can to try to mitigate the harm that gun can cause. So I'm only asking you, and look, it's not fair to you all, but you have some knowledge and expertise. I would think Glock and every other gun manufacturer would want to figure out how to stop that problem along and marry it with the safety feature it has.
So
what do you know about that? If any, it's okay.
Glock attempted to do that with the Gen 6 and the B series.
Okay, that's
It is still something that can be converted, just like any other semi-automatic pistol can be converted.
Okay.
Just by this very nature of being a
What I'm
semi-automatic.
encouraged about, I'm glad they did the B series and the Gen 6 series, and I have a lot of faith in advances in technology. Every time we think we're not going to be able to solve a problem, usually technology comes in with an innovative approach. So what I would hope is that Glock can do better, as well as other gun manufacturers, and come up with better technological fixes.
I don't know of a way to do that. If you take the slide off any of these semi-automatic pistols, you have the interior of the trigger mechanism exposed. It has to be exposed to the slide action for it to work as a semi-automatic pistol. You can, whether you operate on the trigger bar or whether you operate on the sear or re-operate on the connector, you can make a semi-automatic into a full auto.
I appreciate that.
It does, and you can't stop that. Otherwise, it's no longer a semi-automatic pistol.
I appreciate that, and it's not fair of me, but I appreciate your addressing. It's not fair of me to ask you what's the technology going on in the gun industry, and I'm glad you tried to help address it to some extent. And then I know that I haven't had a chance to look at all the data, but I know the proponents of the bill have or will be providing me information about how many, in Maryland generally or outside of Maryland, what law enforcement recovering the casings from these guns, and some cases in which they do suspect that it was manipulated, and we may not have a crime right now that we can point to in Maryland, but we have indices that these guns with this alteration are penetrating the state of Maryland, et cetera. Now, and all I'm going to say is, if it's not in your testimony, any information you want to share about countering any of this data about the rising use of these guns with this very lethal, astonishingly lethal alteration. If you have any, just share it.
I don't have any
okay.
off that hand, but again, I don't dispute the fact that it's been on a rise. Of course it's been a rise, and it should be severely punished, just as it already is under federal law. If you want to pass this a truly effective bill, then make this a felony, possession of a switch, a felony under state law.
Well, unfortunately, after the fact doesn't save lives, and actually, we have enormous penalties in Maryland for all kinds of guns, and people that are and this, you know, you can use this, it benefits you. People that want to commit crimes and want to convert handguns or any other gun are going to do it. They could care less about our laws. So we have another problem about that.
There are 20 million Glocks in the United States.
What?
It's 20 million Glocks in the United States in circulation. That's all over the United States. It is the most popular pistol, single pistol design in the United States.
Oh, this the one at issue here.
Yeah, the Glock design. You have the Glock itself, you have the Glock clones, which this bill also addresses. So what you're doing, you're banning the most popular pistol because of the illegal modifications made by criminals who may not possess that device itself.
I think you have a valid argument, but let me just, I think both sides have valid argument. The last thing is, again, out of the room, are you aware of other states that have passed this kind of law and the challenges to it and the status?
Yes.
And you can, so if you can get back to me, that's not.
Oh, I actually have that challenge
in
in my written testimony. California has passed this virtually identical statute, not quite identical, and it has immediately been challenged. That is pending now in federal court.
Okay.
So that will be litigated in that case. I will say in response to the testimony we heard today with respect to Bruin and Heller, Heller and Bruin both expressly protect firearms that are in common use for lawful purposes. And Glock certainly falls into that category. Nobody really disputes that, given that there are 20 million of them.
And your point being that, you know, Bruin doesn't say you can have a machine gun because they're not in common usage. But your point is a Glock pistol handgun isn't in common usage, which was definitely talked about in Bruin.
So even as to the assault weapons that are banned, none of those bans involve any illegal modifications to the gun itself. So you're taking an indisputably legal device and you're illegally modifying it into an illegal device to multiple grounds, and you're punishing the original manufacturer who produced a legal device, saying, we don't like your design.
Well, that begs the question, are you aware of any cases, it doesn't matter what gun it is, doesn't matter, or what time in history, but do we have any cases in which another firearm was popularly altered illegally to create greater harm, a regulation or statute to limit or ban it, and a challenge and the result?
No, this would be unprecedented. I mean, federal law bans a sawed-off shotgun, but that's because it's sawed off by the criminal. A legal shotgun is perfectly legal. You don't make the legal shotgun illegal to produce because somebody might take and shorten the barrel.
Well, that's a good analogy, quite frankly.
It's a perfect analogy.
Yeah, okay. All right, thank you, Mr. Chairman, thank you.
Senator West and Senator Bolton.
Thank you, Mr. Chair. I'm looking at page 2 of your testimony. I want to read you the same language I read to a witness, I think to the sponsor of the bill earlier. Here's what you said. You said, the mere possession of a conversion device is a major federal felony. And I think you said a few minutes ago that it carries with it up to a life sentence.
Oh, no, I'm sorry. I would like to see a life sentence on it. Not, right now it's 10 years.
10 years, okay. Illegal possession and or misuse of Glocks and such devices in a violent crime are serious crimes under existing state law. Persons who are willing to violate those existing laws will not be deterred by this bill from acquiring Glocks from out-of-state sources and bringing those firearms into Maryland. Would you care to elaborate on your statement?
Because there are 20 million Glocks in circulation in the United States and they're commonly sold and the most popular firearm, it's no small effort to simply acquire a firearm from out of state. Again, illegally, but done all the time. So it is easy for a person who's devoted to the idea of converting an existing Glock pistol into a fully automatic illegal pistol to acquire them outside the state and bring them into Maryland and use in violent crime. It's just the same problem Maryland has always had and every other state has had, the illegal transfer of firearms.
And next, do you have a reasonable opinion as to what percentage of the people who use these illegal conversion devices in order to modify a Glock to make it into a machine gun, what percentage of those people know that they're acting illegally in doing that?
I would suspect almost all of them do, because everybody understands that possession of a machine gun is highly regulated and indeed illegal in most circumstances. They do it anyhow.
So people aren't innocently making these modifications and thereby committing felonies under federal law?
No, that just doesn't happen. What this bill does, by contrast, would make a normal transfer from me to my spouse at the range a criminal act by this bill banning the transfer, even a temporary transfer, on the range to another person, or the receipt to another person. So if I give my Glock, and I do own one, to John here at the range, and he uses it, we both committed crimes, because he's received it and I've transferred it.
Now, another question. Isn't it possible, in your view, to alter virtually any electric appliance in such a way as to electrocute the person turning the appliance on, who is touching the appliance? Wouldn't it be possible to change any electric appliance to turn it into an instrument of death by electrocuting a person turning it on?
Yeah, you simply have to change the wires so they point to different poles on the. Yeah, it's no hard.
But we have not heretofore passed bills in the General Assembly to make it illegal to sell electric appliances, have we?
No, in fact, in my testimony, you'll see the Maryland case law on this is quite clear, is that third-party use of a firearm or other items, including firearms, is not culpable for the manufacturer or the seller, because even though it may be foreseeable, there's no duty to the general public to inflict or impose that on the manufacturer. The case law on that is quite clear, and it's cited at length in my written testimony.
And are you aware of any legislation previously passed by the General Assembly to make it illegal to sell whether an electric appliance, a gun, any other instrument which could be altered by the purchaser in order to make it an illegal device which would kill people?
I'm aware of nothing. So this really cuts new ground by taking something that can be sold legally and punishes the manufacturer for criminal acts of third parties.
All right, let me move to a different section of your testimony. You say the bill's language includes literally every striker-fired pistol, as no striker-fired pistol currently on the market, quote, shields, close quotes, the trigger bar from, quote, interference, close quotes, and you add in parens whatever that means. Could you elaborate on that?
When you take the slide off any semi-automatic pistol, and I own quite a number of them, you have exposed to you in the frame the trigger mechanism. That includes the sear, that includes the trigger bar, that includes the connector, all the things that make a semi-automatic pistol work. None of that is shielded. None. It's simply a matter, the Glock puts the trigger bar in the back. Some of the other manufacturers put the trigger bar further up into the frame, but it's all accessible. None of it is shielded. Right, so the mechanism, the definition for a converter, pistol converter, includes anything that interferes with the trigger mechanism. And that can be done with any striker-fired pistol.
You will go on to say the bill does not define the term, quote, readily convert, or the term common household tools, or the term shielded from interference. And you say, without definitions, it's simply guesswork whether a given striker-fired pistol is covered. Can you elaborate on that statement?
Because we don't know what readily convert means, and this is what distinguishes this bill from the California legislation. At least they define what common tools are. This common tools is not even defined. We don't know what makes readily convert. People can readily convert, in some sense of the word readily, a Sig Sauer M17, and you have, again, a link to where someone has actually done that. And that's the very pistol that the Attorney General said in his bill, his complaint filed in Circuit Court against Glock, was not directed at because it was shielded. It's not shielded. It's nonsense. And it's no trick to make a switch that acts on that trigger mechanism.
Thank you. Now, as I'm sure you are aware from my questioning of your testimony on prior bills, I'm very concerned about bills which impact the U.S. Constitution.
Oh, yes.
So I get to the point in your testimony when you say, in short, the language of the bill is poorly drafted, hopelessly vague, irrational in its application, and vastly overbroad. Such a bill is a violation of the Due Process Clause of the 14th Amendment and Article 24 of the Maryland Declaration of Rights. Could you give us more details as to how this bill, in your view, violates the Due Process Clause of the 14th Amendment and Article 24 of the Maryland Declaration of Rights?
Both of those provisions ban the use of legislation, especially criminal legislation, that is vague. So the undefined terms make this bill vague. The overbroadness comes from actually criminally penalizing all transfers or all receipts of an existing Glock pistol that's not been converted. When I hand my Glock 19X to John at the range, we've done, both of us are now criminals because he's accepted it, he's received it, and I have now transferred it, albeit as a temporary transfer. So the bill does make a distinction for temporary transfers to FFLs, but it doesn't make that distinction or use of temporary transfers anywhere else. Normal rules of statutory construction provide that whereas legislature has used a term in one sentence and doesn't use it another, that by necessary that definition in places where it's not being used indicates a congressional intent or legislative intent to actually ban it without that modifier. So by allowing temporary transfers in some contexts and not in other contexts, you basically banned all transfers, except where temporary transfers are now otherwise provided. So it is sweeping in terms of potential liability. And you're leaving it up to a law enforcement agent to make that determination ad hoc on the spot. The case law is really quite clear, and it's cited in my written testimony, that where you leave, the bill is so vague that it leads to arbitrary enforcement. That's a violation of Declaration of Rights and the Due Process Clause of the 14th Amendment.
Now, at the bottom of page 8 of your testimony, you connect the concern about vagueness with the Second Amendment. This is the first time you mentioned the Second Amendment in your testimony, and here's what you say. Just as a law that interferes with the right of free speech or of association demands a more stringent vagueness test, so too does a law that prohibits people from acquiring the arms that the Second Amendment entitles the people to keep and bear. Can you explain that a little more?
Well, that's just a basic principle of constitutional law, where you have a protected, constitutionally protected right. If you're going to regulate that right, legislatures must do precisely if it hopes to survive, because the idea there is that if you make a vague law, you're basically infringing on areas which aren't justifiable. So you need precise legislation if you're going to regulate the acquisition of arms, just like you do when you regulate speech. And the Supreme Court has said over and over again, you don't treat the Second Amendment as a second-class right. They said it in Bruin, they said it in McDonald, and it's clear from Heller as well. And just because other firearms are available, that argument was rejected expressly in Bruin, where it said just because you can use long guns doesn't mean you can ban handguns. Just because I can buy a hammer-fired handgun doesn't mean that I can't buy a striker-fired firearm. So you're banning a whole class of firearms here.
Now, I'm over on page 10 of your testimony where you say, banning guns in common use because third parties can make illegal modifications and conversions is a facial violation of the Second Amendment. How so?
Well, Heller has established as a first principle that guns in common use are constitutionally protected. In order to survive under Bruin, to adjudicate those as illegal, you have to establish an historical precedent for them. So I'm very familiar with this area of law because I litigate it all the time. I can't think of a single historical law where a legislature has punished the illegal conversion of a instrument of harm, a weapon, that was legal before, but it's now illegal. So, for example, there is some historical analogs that ban concealed carry of Bowie knives. Well, that's the Bowie knife itself, not the illegal conversion of the Bowie knife. So no law that I know of ever historically or even to the present has banned a firearm because it can be illegally converted. So that's the distinction between bans on AR-15s, which this legislature has enacted, and a ban that you would inflict. It takes the AR-15 ban to the next step because it could be illegally converted into a machine gun. Now, AR-15s can be illegally converted into a machine gun too, but that doesn't mean you can ban all AR-type 15s. The Supreme Court has said, after denying cert in the Scopes case, that's the Maryland assault ban, that Justice Kavanaugh said in concurrence to that cert denied, that we're going to take an assault weapons ban either this term, this coming up term, or the next term. There are at least 2 petitions for cert presenting that question now before the Supreme Court. I anticipate by the end of this term, the court will likely grant at least one or both. If not this term, next term, because it's the next issue that the court has to address. Now, the court is already addressing the who in the case called United States versus Humani. It's addressing the where in the case that I'm involved in called Wolford versus Lopez. So the assault weapons ban is the next kind of subject matter that's actually going to be addressed by the court.
All right. Thank you so much for your answers to my questions.
Thank you, Mr. Chair. Thank you all for your testimony. I'm really sorry I was late. I was at another hearing, so unfortunately I missed the first half. I'm sure I'll get caught up by my good friends from every town. So, Mr. Penick, can you describe, I guess, for lack of a better word, but can you describe the position or the approach that this body has taken, meaning this legislative body, to hold those who illegally possess and or use a firearm in a commission of a crime? I mean, can you give an idea of how this body has taken those illegal possessors of a firearm, utilizing them in an illegal act? Has this body been moved towards more leniency and returning them to the street sooner, or have they held them accountable for the violations of that law?
Well, there's 2 questions embodied that.
Sure.
The legislation on the books authorized rather severe sentences for the illegal use of a firearm in a crime of violence. It's 20 years.
Mm-hmm.
The use of a firearm in an assault, for example, can be punished by, I think, 25 years. If you use that in a crime of violence, and that authorizes another 20 years, so there's 45. So you're already down that path. So now if you take a pistol that's been converted, you've got a 10-year federal felony, you got a 3-year misdemeanor charge on state law on top of that. So you're up to 48 under state law and 10 years in federal prison as well. Maybe you can make it a capital crime. I'm sorry, you can't do that in Maryland. But I don't know that these people care, who are actually using these converted pistols of what the punishment they're going to receive. I would think it would probably drop off rather dramatically if the courts start actually imposing these maximum sentences.
That's a great point. That's kind of where I was leading, which is we have courts in, and each jurisdiction is different, obviously, but that are really lacking to hold them accountable through proper sentencing and accountability, because Maryland has taken more of a hands-off, well, we're gonna reintegrate back into society sooner and less accountability, and they return to the streets. And we're seeing through your 51-page testimony, is it 58? I'm sorry. Okay. Which is very thorough, by the way.
Thank you.
I'm seeing incidents where you were talking about officers responding to certain incidents, and in those incidents that it was like 70% of those people were not, were prohibited
Oh, yeah.
But I guess my
expect that
next-
probably most of them are prohibited by far.
So my next question is, not only were they prohibited because of previous criminal activity, but of those, we're not even caring to determine the numbers that were carrying them without proper training according to what Maryland requires.
I'm certain that none of them are.
Well, that would be probably not far off, I would guess. So again, we're lacking just simple things where we're constantly passing laws, we're constantly moving the needle against the legal gun owner. And because of the actions of a few, we now are looking once again to pass legislation that is going to impact the overwhelming number of legal, lawful firearms owners.
I would love to see state prosecutors in this state actually prosecuting these sort of crimes to the fullest extent of the law.
Yeah,
And that
me
would
too.
require incarceration.
Me too.
I mean, let's be clear on that.
Thank you. So November 30th, 2025, pretty important date. Glock says, you know what, we're going to stop this. We're no longer going to offer these handguns, which as manufactured, were not illegal. We're actually quite popular. Fair?
Fair.
Okay. How long, once the Gen 6 and B models came out, or series came out, do you know how long it was before someone was able to do the exact illegal modification after it was made available?
A week.
It was less than a week, right?
Right.
It was less than a week.
Yes.
That someone took a firearm and was like, well, let's see what I can mess with next. And by doing so, did they commit a crime?
Oh, yes.
That's already on the books.
Oh, yes. Major federal felony.
Thank you. So when people go through training in Maryland, whether it be HQLs, concealed carry, whatever it is, the legal gun owners, are they made aware that to modify a handgun in any capacity, firearm, to make it fully auto, we keep throwing around like machine guns, but to make it fully auto, is illegal?
So yes, because all these instructors are required by a curriculum published by the Maryland State Police to instruct in state law. And state law directly addresses this. We're also instructed to instruct on federal law.
Right.
And I do that. I know John does, and most instructors do because we're required to.
Was there any testimony presented on the number of legally trained, lawful firearm handgun possessors who were arrested in Maryland with this illegal switch?
None, because almost by definition, if you got the switch, you're a criminal.
So the people that went through the lawful process got certified to be responsible gun-carrying citizens as in accordance with their Second Amendment right. We have 0 arrests on the books for modifications contrary to what this law is prohibiting.
I know of no otherwise lawful gun owner that's been arrested. Mostly you get youths doing this who can't even possess a regulated firearm because they're under 21.
It's like he's got ESP or something. So when I'm looking at some of the testimony here, and I don't want to read directly from it, but there are numerous examples, especially when we're talking about certain communities in the state of Maryland, that these type of modified firearm handguns were taking off of individuals who had no legal authority to have the gun whatsoever.
Correct.
And had no training, and the gun, there are a high frequency of those times that the gun has actually been stolen or illegal anyways.
Stolen guns are crime guns, absolutely.
And again, it goes back to we have people in possession of stolen handguns, and then we don't have the accountability on the backside of it. Is that fair?
That's fair.
And then, you know, my good friend here, she made some wonderful points from Harford County, and she talked about, you know how car manufacturers, they like to make gun or vehicles safer, and it's an evolving technology, right? And it's the same thing with firearms. Like we've seen, the Striker Fire is a much safer version of a handgun with almost 0 ADs.
Oh, absolutely, particularly the Glock, which is remarkably safe. I've never had a malfunction with the Glock.
Right. So is it fair to say that someone could go buy, I remember there was a time, these Nissan GT350 super drifting cars and all that you'd see all over the movies, that people would buy those cars and they would put a system in them that was nitrous.
Oh, yeah. Make them race cars.
Makes them race cars. But nitrous, the use of nitrous on any roadway in the state of Maryland, I don't know if you're aware of this or not, is
banned.
Absolutely banned. But does it not make the vehicle less safe, more dangerous, and a higher propensity for that operator to work outside the manufacturer's specifications
Absolutely.
of performance?
And indeed, cutting the muffler and the catalytic converter off to have better throughput and higher horsepower also makes it illegal on the roadways. But people do it anyhow.
Yes, and you can usually hear them.
You can.
So, again, I just want to show that there's no legislation in this body right now to ban cars.
I hope not.
We have vehicles that are being modified, and it's obviously a case by case basis. But just like this case that we're talking, or this bill that we're talking about, it's really talking about those that are already bad actors doing bad things that is already federally prohibited.
I would like to see mandatory minimums on possession of a Glock switch.
I love that idea. That's a great amendment.
So if you want to amend this bill to impose mandatory minimums and pass that, I'm all for it.
Well, you know what? I think I will offer that amendment. I think that's a great idea, and I appreciate your time. Thank you. Thank you, Mr. Chair.
Thank you, and I appreciate my good friend bringing up something. So it seems to me what your testimony is that in some ways, whether intentional or not, bills like this reflect the failure of Maryland to adequately punish and or rehabilitate criminals who buy illegal firearms or convert firearms into illegal ones, and otherwise get our skyrocketing criminal violations under control when it comes to guns. In other words, we go toward a business lawfully existing, selling lawful products, because we have failed to find a way to hold criminals accountable and bring down the numbers that engage in this criminality and use these guns, which is awful, and I don't think anybody wants this to be happening, but somehow we are failing in that regard.
You are, because the incidence is rising, because people think they're not going to go to jail for it. So if you actually can start sending people to jail, you will increase the deterrence value of existing laws.
In fact, we have a bill that we're considering now that will take certain traffic violations and make them secondary, despite the fact that law enforcement says many of these traffic violations that they stop people for are a very fruitful and one of the most significant ways they recover illegal guns.
Yes.
So I mean, not that we intend to assist with additional illegal guns or not protect the public from criminals, but sometimes we put bills in that do just that.
I spent 3 years at the U.S. Department of Justice. Officers are trained, and properly so, to use otherwise lawful stops to investigate for other crimes. Now, there's constitutional limits on how they can do that and where they can go with that, but that is part of the law enforcement's duty. And the more you make that duty difficult or illegal, the more you're going to get more of those crimes that would otherwise have been uncovered, including illegal guns.
And sort of, I guess the last thing, and this is, it's not, it is a question, but I can find some of this myself, probably across the country, and there are probably studies as well, have shown what are the most effective laws to pass and the most successful strategies in implementing those laws that do in fact bring down criminality and guns, which is what the groups here want. They want to protect the public from all the death and mayhem created by guns, and I don't think anybody in this room doesn't want to do that.
Amen.
But I think you're going to be able to provide me studies and data that show passing yet another bill about restricting guns in Maryland, of which we have many, or a bill that deals with criminals and guns not effectively enforced is really the core of this, and data will support that.
I think that's too obvious to admit of dispute. So the idea that you're going to force Glock to change its design, well, Glock has changed its design, but just now we're hearing not good enough. So the idea that you're going to force Glock to change another time beyond what's its V series is fantasy. They'll just leave the Maryland market.
Well, that's what they want, right?
I mean, that may be, but that's not going to keep Glock pistols out of the
Yeah, and
Maryland.
it's not going to solve our crime.
It won't even come close to solving the
Which is what
problem.
I hope we would focus on. All right, thank you, Mr. Chairman.
Thank you very much. I think I understand, but I just want to make certain and just ask you clearly, what regulatory powers do you believe that a state has in regulating the design or the production or the manufacturing of guns?
The state's powers are limited, first of all, by the Second Amendment, second by the Commerce Clause, and other constitutional provisions that bear on that subject. But in the Second Amendment, the state may not ban, including ban for acquisition, the acquisition of firearms in common use. Full stop. Glocks are in common use, that's the stop. Now, to come to step 2 of Bruin, you're going to have to show an historical analog that suggests that criminally modified firearms can be nonetheless banned in their non-criminal form because criminals can modify them. So I know of no historical reference for that. Now, the Supreme Court will illuminate the scope of the historical inquiry in 2 cases now pending in the U.S. Supreme Court right now. United States versus Fermani and Wolford versus Lopez. Both of those would call for the court to apply Bruin Step 2, which is the historical search for historical analog. So we'll get further guidance from the court right now. But right now, there has to be at least a how and why the ban was imposed. So you're imposing, you're going to have to be able to show a historical analog that shows that there was a ban on common use firearms because they were illegally modified.
But I guess that's where I'm different on the premise. You're talking about bans, and from the proponents, I didn't hear anything about banning weapons. What I heard about was modifying how weapons are designed.
To the contrary, it bans the sale, receipt, offer for sale, transfer of all these Glock pistols. It bans the sale, doesn't ban the possession, but the Second Amendment right includes the right to acquire, includes the ancillary right to sell. But it certainly includes the right, every single court of appeals to address that subject has held there's a constitutional right to acquire commonly used firearms.
But are those bans if they are not modified so that they can't be modified? So it's not a ban, it's actually a modification on the design.
So this bill doesn't require modification of a design. It bans the sale and receipt and transfer and offering to transfer a firearm.
Okay, so let me ask you this another way. Can the state of Maryland regulate the design of a gun?
So that would pose again, a constitutional question, and it would also pose a commerce laws question, and whether or not you can, by legislative edict in Maryland, control the design of a gun manufactured outside of Maryland. And none of these guns are manufactured in Maryland.
But I know there are electronic products like televisions that California regulates differently than the state of Maryland.
Sure, and if a manufacturer wants to not sell into California, he
then
has
that's their
that
choice,
option.
right? Correct. So a state can regulate the design of a product coming into its territory.
It can, and Glock will simply not sell into Maryland.
Okay, I just wanted to thank you.
Which means that all the state police and other police departments will not be able to replace their existing Glocks with the upgraded Glocks.
Further questions from the committee? So then I just have a couple questions on the third party, the duty owed to a third party. And you go into this in your testimony. You cite 2 cases that talks about the duty that a manufacturer in this instance would have to a third party. I think one is the War case, which is a dram shop case. I think that's out of Montgomery County. And then the Target case, which had to do with the Valentine case that you cited. Yeah. Can you walk us through just what the courts in Maryland have said with regard to third party, to in this case, a manufacturer's duty to a third party? And yeah, walk us through those two cases and what the courts have said, and then I'll pivot to another avenue that I think might be available here in Maryland, but go ahead.
Maryland has a very strong case law on the presence or absence of a duty, and the duty of a manufacturer or seller or of anybody for the criminal misuse of the item which is being sold. And Maryland Supreme Court and Court of Appeals, before it became the Supreme Court, has held quite definitively that there is no duty to the public where there's no special relationship with either the plaintiff or with the person who buys the firearm or other item from the manufacturer or the seller. So there's simply not a general duty to the public at all. So that's regardless of foreseeability, by the way.
So we've done, I understand that. So we've criminalized the switches, we've criminalized the activity, but that's an illegal activity, as the senator from the 4th District has talked about. And so under our current tort regime, in terms of that duty to the third party, even regardless of the foreseeability piece,
right,
and absent a special relationship, our courts have said, hey, there's probably there's no duty here.
There's no duty, hence no liability.
Understood. Then so we've done, what about where the vice chair's bill we passed, I don't know, 2 years ago? For the
2024, the nuisance suit?
Yeah, for under the theory of like public nuisance. Like could something be pursued under that avenue?
Well, that does seek to impose that kind of liability.
Yeah, what do you think about the prospects of that, is my question.
That litigation is right now pending against Glock in Circuit Court in Baltimore. And there is a motion to dismiss filed by Glock in that case. It's pending now. That was heard orally in October. No decision yet on that. I have yet to, I don't know when that decision will come out, but I think Glock has very substantial defenses under the PLACA, Protection of Lawful Arms Act, and under Maryland law against the liability that bill seeks to impose. I have other problems with that. You know about them from the testimony I submitted on Senator Wildstreicher's bill. But that bill is still on an outer edge of liability, seeking to impose liability on firearms sellers and manufacturers. And so we'll see how that litigation turns out. I suspect that Glock will eventually prevail on that on one or more either state law grounds or state or federal grounds.
We shall see. All right.
I have one question.
Yeah. Sure.
So hearing the discussion, it made me think also when we were discussing about, that the state has the right to intervene or prohibit certain sales of things within their state, right? But does the state, again, under the supremacy clause, have the right to prohibit, like, the legal possession of a firearm?
No, it may not. It's not just under that's under the Second Amendment, where the supremacy clause applies to every court in state, federal, and state.
Correct. So when I'm looking at, like, I liken it to the idea of we have the federal motor vehicle safety standards. So we have a federal guideline that says any manufacturer, regardless of where you're from, as long as you meet these safety guidelines, you can sell in any state in the country.
Yes, that's by federal preemption by.
Okay.
That's right.
So now, can you take those cars and modify them to make them less safe? The answer would be yes.
Of course.
And I'm likening this to the same idea, the same premise, that as long as they meet the same safety guidelines or the same, not safety guidelines, but it's the same operational and protected facets of the Constitution, and they're not built in a manner that is contrary to federal guidelines already, which already makes this a felony. And sadly, we had the one manufacturer that we had in Maryland up and leave because of overregulation. Is there currently, like, I just struggle with the idea that Maryland thinks that they could be able to tell them that they can't sell those here, any weapon that could be modified, which would be any semi-automatic handgun.
Correct, and believe me, it will be challenged, just as the California bill has been challenged.
Yeah. Okay, thank
I
you.
will lead that charge.
Thank you.
I'm sure you will. But so what is the Handgun Review Board in Maryland? What do they do?
The Handgun Review Board?
Yeah.
Or you hit the Handgun Roster Board?
The roster board, yeah.
The roster
What's on the
board
roster?
by-
What's
by-
their charge? What's their charge? What's their mission?
Their charge is to investigate the safety of handguns that are offered for sale. Nothing that's not safe makes it onto that roster.
So they have the ability to determine what you can sell, what firearms can be sold in the state of Maryland?
Under specified criteria, yes.
Can they, at current time, take things off of the roster?
No.
Okay. If we were to change that, what are your thoughts?
Well, you would have the same Second Amendment arguments I have now.
All right.
And believe me, I do that too.
That's a forthcoming conversation. But. All right, go ahead.
Thank you. So, excellent question from the chair, and I just want to follow up on that. You know, I've looked at the firearm roster in the state of Maryland, and I've always been befuddled by the idea that there's a certain provision that requires Maryland to only allow for the sale of heavy barrel rifles.
Yes. Yes, it's
Can you tell me?
5-101.
Can you tell me exactly? Can you explain to us why Maryland says it's so much more important to have a barrel that is heavier, less expansion, meaning more accurate at long distances, over a barrel that is?
I would like to adjust it, but
Yeah,
I know
no,
John
that's
would
fine.
too. But
I'm going to have to ask you to stand up, though, sir. Sorry.
The term heavy barrel came in with the Colt Firearms manufacturing with what they developed, what they called the H-bar, which was the heavy barreled AR rifle.
Mm-hmm.
And for reasons known only to the General Assembly, they decided that the barrel weight made the rifle somehow better. It did from the standpoint of it being a target rifle. However, the term H-bar was for a proprietary item, which is no longer manufactured. The definition of H-bar is nebulous. There is no legal definition of what a heavy barrel rifle is.
And that's where I was going with this. Is there any definition or nexus to the idea that Maryland has a list that prohibits certain rifles that are not stamped with this H-bar, or the heavy barrel, the HB, that makes them not for sale in the state of Maryland?
I can tell you that the state police control this interpretation. So according to the state police, that if a manufacturer designates it as a heavy barrel rifle under otherwise banned AR type construction, it becomes a heavy barrel rifle, and maybe so. They have a list on the state police website that actually identifies it by model, by manufacturer, which are H-bars and which are not.
So my closing question is there a difference in performance and functionality, basic functioning of an AR that is stamped with an HB and one that is not stamped?
Well, they heat up less than a regular barrel. That makes them more accurate over time.
Yeah.
And heavy competition use, for example.
So Maryland wants to make sure we have more accurate firearms.
Well, I compete with
accurate.
H-bars, so I like that feature, but it doesn't make the firearm less dangerous.
It still fires the same. The mechanics,
fires the same bullet.
Functioning, the whole process.
Yeah.
Thank you.
All right, seeing no further questions from the committee, thank you all very much. With that, that'll conclude the testimony and the hearing for Senate Bill 334. We're now going to move on to Senate Bill 290. Senator had a prior obligation, so I think we're going to have, Jordan, you're going to come up and present Senate Bill 290, and then go on to Senate Bill 327 after this testimony.
Good afternoon, everyone. My name is Jordan Wolford. Senator McCray sends his apologies, so I'll be speaking on his behalf as his intern. Today, I want to say thank you to the chair, vice chair, and the honorable members of the committee. I respectfully submit this testimony in strong support of Senate Bill 290. legislation that strengthens Baltimore City's ability to enforce local ordinance and protects public health and safety and quality of life. Oh, didn't read the name, so I'm going to read the name for you guys as well. Baltimore City Ordinance Enforcement, Amount of Fines and Penalties. Senate Bill 290 authorizes Baltimore City to increase the maximum allowable fines and penalties for the violations of local ordinance, rules, and regulations. By updating these limits, the bill ensures that enforcement tools remain effective and reflects the current economic and regulatory environment. Many existing penalty caps are outdated and no longer serve a meaningful deterrence. As a result, some repeat or serious violations may go unaddressed, undermining neighborhood stability and public confidence. This legislation gives the city greater flexibility to hold bad actors accountable while maintaining appropriate due process and oversight. Strongly enforcement authority supports cleaner neighborhoods, safer housing, and improved compliance with health and safety standards. It also helps protect responsible residents, and business who allows the law and invest in their communities. By modernizing enforcement mechanisms, Senate Bill 290 promotes fairness, accountability, and stronger local government in Baltimore City. Thank you. Also, I'm joined by Ms. Nina and Baltimore City.
Good afternoon, members of the committee. Nina Themlis, Director of Government Relations for Mayor Scott in Baltimore City, here to testify in support of Senate Bill 290. Senate Bill 290 would make one change to Article 2 of our city charter. That is the general powers that are given to the city by the state. It would be updating a penalty amount, a maximum penalty amount that was established in 1982. So just wanting to update that maximum amount 43 years later. There was a bill that was passed by the General Assembly back in 2024 that increased the maximum penalty amount for all charter counties. So we're just looking to also receive that same benefit of increasing that maximum penalty amount. The main reasons or main benefits of increasing that maximum threshold is that we want to encourage behavioral deterrence. So $1,000 today is not the same as what $1,000 meant in 1982. And so by allowing us to increase that maximum penalty amount to $5,000, we're hoping to have a similar effect as $1,000 was meant to have in 1982. I also just want to underscore that this is just authorizing the city to increase maximum penalties and fines. It does not automatically increase the penalties and fines. Additional processes would have to happen before the city council, where individual evaluations would be performed of the fines and penalties and determine which ones should be increased. Increasing the maximum would also help us with some compression issues that we experience as we have a number of fines and penalties that are a part of a graduated system where lower amounts are charged and then the fine amount increases based upon the severity of the penalty, and having that cap at $1,000 prevents us from being able to apply reasonable fines and penalties for equivalent actions. Two main issues that we'd like to really address with this increase are issues with illegal dumping. We process about 15,000 illegal dumping complaints per year, as well as additional efforts toward our vacant housing initiative. We process about 7,800 complaints for unabated vacant housing notices. Thank you.
A two-out intern. I just want to say, young lady, there you are. Stand up a second. Is this your first presenting a testimony?
Yes.
It is. Well, you did a great job. You did better than this guy ever does. So I commend you on that.
Thank you.
Good job.
Excellent. All right. Thanks a lot. Thank you both very much. Seeing no further questions, thank you. That'll be the end of the hearing for Senate Bill 290. Oh, wait, hold on. Sorry, my apologies. Sarah Price, come on up.
Good afternoon, Mr. Chair and honorable members of the committee. My name is Sarah Price, here on behalf of the Maryland Retailers Alliance to share some concerns about the proposed fine increase. We actually sympathize very much with the issue of illegal dumping. This is something that does impact businesses when they have dumpsters that are often the target for community members. But contrary to the fiscal note's prediction, this increase could have a meaningful impact on businesses that find themselves with an infraction, regardless of a good faith intent to follow the law. The city code allows some civil penalties to be escalated and pursued as a criminal misdemeanor, and increasing the maximum fine here can compound punitive exposure. Excessive penalties can lead to litigation, it can delay remediation, and it can result in an accumulation of legal debt. For small businesses that are operating with very thin margins, a $5,000 fine could result in closure rather than compliance. Even the perception of revenue-driven enforcement can undermine public trust, and we would caution against policies that don't serve to attract new businesses to the city. When we testify before the City Council, we advocate for graduated enforcement of ordinances, warnings for first violations, and reasonable payment options, in addition to the use of common sense discretion when enforcing ordinances. So we will continue to urge the city to work with businesses to achieve code compliance, and would respectfully ask for an unfavorable vote. Thank you.
All right, seeing none, thank you very much. With that, that really will conclude the hearing for Senate Bill 290. We'll now move on to Senate Bill 327 with Senator McCray. But Jordan, welcome back.
Okay, hi. So for Senate Bill 327, the Senator for drug paraphernalia and controlled paraphernalia prohibitions. Is it okay if the panel joins me? So we're going to have Crystal Billups, Darcy Kerwin-Gerber, Ron Phillips, and Michael Abram join me. Senator McCray remarks read, I respectfully submit this testimony in support of Senate Bill 327. Senate Bill 327 is a common sense public health and public safety bill that updates Maryland's paraphernalia law without weakening drug enforcement. Right now, legally obtained household items like spoons, scales, or small plastic bags can be treated as a criminal paraphernalia based on suspicion alone, even when no drugs are present. This bill brings clarity and fairness by ensuring legal items remain legal. Senate Bill 327 will also reduce syringe litter and improve safety in our communities. When people are not afraid of arrest, they are more likely to carry used syringes and dispose of them properly. This means safer sidewalks, playgrounds, and neighborhoods. The CDC supports policies like this to reduce syringe litter and related risks. In addition, this bill strengthens Maryland's overdose prevention efforts at no cost to the state. Ending paraphernalia penalties increase participation in syringe service programs, which can reduce overdose, prevent HIV and hepatitis C, and save taxpayer dollars, which it also allows the Department of Health rapid analysis of drugs programs to expand statewide, giving every county better data on the litter drug supply. At this time of $1.5 billion budget shortfall, this is a practical and cost-efficient solution. Finally, Senate Bill 327 does not legalize drugs or weaken law enforcement. Drug possession, safe, and manufacture remain illegal, and states with similar laws continue strong enforcement efforts. For these reasons, Senate Bill 327 is a balanced and responsible approach. I respectfully ask for a favorable report. Thank you.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Crystal Billups, and I serve as the Assistant Deputy Mayor for Health and Human Services for the City of Baltimore. This is a priority bill for the Baltimore City Administration. I want to address a common concern up front. This bill will not increase or encourage drug use. Instead, it will make it easier for people to access services that are proven to reduce drug use and overdose, and it will also save money. I'll explain that shortly. The Baltimore City Health Department operates a program called an Opioid-Associated Disease Prevention and Outreach Program, sometimes known as a needle exchange. According to the CDC, People who participate in these programs are 5 times more likely to enter drug treatment and 3.5 times more likely to stop using injection drugs. These programs treat people with dignity. They provide peer support, overdose prevention education, STI testing and treatment, and referrals to drug treatment for people who are ready. They also provide sterile syringes and collect used ones. This is extremely important for stopping the spread of HIV and other infections, thereby saving money by averting healthcare costs. This bill is critical because our current paraphernalia laws deter people from using these programs. The statutes governing these programs exempt clients from being found guilty of violating paraphernalia laws. However, we hear directly from constituents that they are still afraid to participate due to fear of criminalization. Passing this bill will remove that barrier. It will help prevent overdose deaths, it will lead to a decrease of use in injection drugs, and it will save money by keeping people healthy. On behalf of the Baltimore City Administration, I respectfully request a favorable report. Thank you.
Hello, Chair, Vice Chair, members of the committee, good afternoon. My name is Darcy Kerwin-Garber. I work at BHRC, which is a syringe service program, or one of the programs you just heard about that is located in Baltimore City. We are in strong support of SB 327. So we work with hundreds of Baltimoreans every week, people who are actively using drugs and actively trying to navigate survival within addiction and oftentimes within extreme poverty. And what we hear consistently from our participants over and over and from other programs like ours throughout the state are that our paraphernalia laws are causing direct harm, that people are still getting stopped, they're still getting questioned by law enforcement even when they have these protections. And that causes people to be extremely fearful of engaging in our programs and then taking on riskier drug use habits. So our organization also participates in that rapid analysis of drug state program, the RAD program. This is one of the only tools that our state actually has to know the illicit drug supply and what's happening. So that's extremely important for medical providers on how they respond to overdose, depending on what's in our drug supply, the type of test strips that we can hand out to our participants, and our safety measures and how we respond to overdose crises. So right now, with our current criminalization of paraphernalia, only programs like ours are able to participate. That means that right now, half of the counties in Maryland have little to no data on their actual illicit drug supply and what people are actually using. By removing penalties for paraphernalia, that opens up to an additional over 300 programs throughout Maryland in every single county so that you have timely data of what people are using and how best to protect them and find stabilization. So that we are not trying to take a tool away from law enforcement. This is an acknowledgement that this very specific tool is causing harm and undermines public safety, that it keeps people away from the services that can actually save their lives and connect them, and that individuals are trying to find recovery, and this is harming them. So for that, we request a favorable report. Thank you so much.
Thank you, Chairman Smith and committee members. My name is Ronald Phillips, and I have been working in behavioral health for several years. And I'm also a person with lived experience. I'm here in support of Senate Bill 327 to repeal Maryland's paraphernalia law. I would like to share a story from my past about how paraphernalia laws had kept me in a cycle of use and arrest. One time I had been using in the Pennsylvania Avenue section of Baltimore, and I was questioned by the police, and they wanted to know about, information about the drug dealers in the neighborhood. I didn't know the answer to these questions because I'm not from that neighborhood. This infuriated the police, and they began to search me, and then they eventually charged me with paraphernalia. This did not help me. This actually made me distrust the police, and I just didn't want to get help because I thought that maybe if I get help for my condition, that I would be arrested or tried for just having paraphernalia. And also that experience made me use in areas that was more dangerous because I felt like I would be, hidden better. And even times when I wanted to seek help for my substance use, I felt nervous to go to a clinic because, like I was going to be stigmatized or even, again, arrested for having these paraphernalia on my person. But this is just my story, There are so many people that had this experience, and I know from my lived experience and my work in the community that ending paraphernalia penalties is just overdue and it's common sense. Please give Senate Bill 327 a favorable report and end paraphernalia penalties now.
Members of the committee, Michael Abrams, I'm a senior attorney here on behalf of the Network for Public Health Law. We inform policymakers on legal barriers and legal solutions for evidence-based public health actions. I want to emphasize 2 points in our written testimony. First, this is an evidence-based public health measure. Decades of research supports that increased access to safer use supplies prevents disease transmission and leads to better health outcomes, including on measures like overdose prevention and treatment entry. There's not evidence that legal access to safer use equipment increases drug use or risk-taking. Think about how this works in practice. Any person who's in need, who seeks safer supplies, is taking a step to protect their health. When they have to risk criminal liability to do that, they're less likely to come forward. Maryland invests in resources for these community members. You want people to feel safe to participate. That's what this bill would help do. Under current law, there is protection for supplies obtained from state-authorized programs, but it functions as an exception to the general criminal rule. I can talk more about this if there are any questions, but the bottom line is that full legal access would be a significant improvement from a public health perspective. The second point I want to emphasize comes from our work in legal epidemiology, which essentially means research to map the state of the law across jurisdictions. Having studied the paraphernalia laws in every state, I can tell you that this bill is not extreme or unprecedented. It would take Maryland from lagging behind to being in line with a significant group of leading states that already provide legal access to the most essential safer use supplies. We urge you to join that group in following the evidence base and to issue a favorable report on this sound public health policy. Thank you.
All right, thank you very much. Questions from the committee? All right, thank you all very much. Thank you for your testimony. We're now going to move into Michelle Livshin here. And Max Romano. Timothy Bradford. Dan Rabbit. Repeat. Go ahead.
Thank you, Chair, Vice Chair, and committee members. My name is Michelle Livshin, and I'm here today representing On Our Own of Maryland. We're a statewide peer support, education, and advocacy organization with a network of affiliated peer-run wellness and recovery centers that has served 10,000 community members with mental health and substance use challenges in the last year. On Our Own of Maryland is in strong support of SB 327. Since 2016, established syringe service programs and their participants have been made exempt from the criminal offense of the possession of specific drug paraphernalia. However, harm reduction program workers, family members, loved ones, and peers all put themselves at significant risk of being arrested when delivering or utilizing different types of supplies to help reduce health risks. The threat of law enforcement involvement and/or incarceration based on paraphernalia laws creates fear and stigma that deters community members from engaging. Our network of peer-run wellness and recovery centers has seen this many times in Washington, Frederick, Carroll, Hartford, and Baltimore City. We've heard individuals who will not participate in their local needle exchange programs due to the very real fear of being arrested and forced through the traumatizing experience. Across the U.S., 20 states have already taken steps towards decriminalization of personal harm reduction supplies. Eliminating penalties for paraphernalia in Maryland is essential to expanding harm reduction programs and practices that help keep our communities safer. SB 327 is a life-saving legislation, and we urge a favorable report. Thank you.
Good afternoon, Chairman and committee members. My name is Max Romano. I'm a family doctor and medical director at Healthcare for the Homeless in Baltimore City. I've cared for people who use drugs in Baltimore for the last 15 years. I urge a favorable report on SB 327 for one reason, and that is that this bill can save lives. When drug paraphernalia is criminalized, it doesn't stop people from using drugs. Rather, it makes their use more dangerous as they resort to reuse, share, and utilize substandard paraphernalia. I've never met a person who quit drugs because the paraphernalia was criminal, but I've met many who were harmed and killed by unsafe paraphernalia. Although you've heard for years about increasing overdose deaths, I think the focus on overdoses has overshadowed a parallel increase in deaths due to infections associated with drug use. Now, to be clear, drugs cause overdoses. Unsafe paraphernalia causes infections. In addition to chronic viral infections like hepatitis C and HIV, unsafe paraphernalia leads to bacterial and fungal infections of the skin and soft tissue, endocarditis or infection of the heart valves, osteomyelitis of the bones, spinal abscesses of the back, and sepsis. 70% of people who inject drugs report skin or soft tissue infections, and especially among older drug users, the risk of dying due to an infection is 2 to 5 times higher than the risk of dying due to an overdose. And again, to be clear, drugs don't cause infections. Unsafe paraphernalia causes infections. Every time that a needle is used to inject into human tissue, its surface is damaged. If you look in an electron microscope at the tip of a needle, after a single injection, you'll see that it's dulled and the smooth surface is pot-marked. That dull needle damages tissue as it's used to re-inject, and the pot-marked surface harbors infectious particles that can transmit infections. I see patients every day dealing with the long-term consequences of damaged veins, destroyed heart valves, and festering wounds, and this bill can save lives. Please provide a favorable report.
Chair, Vice Chair, members of the Senate Judicial Proceeding Committee. My name is Tim Bradford, and I'm a public defender from Caroline County, and I am in favor of Senate Bill 0327. 1971, President Nixon declared a war on drugs. 54 plus years later, the pandemic of drugs is still with us. The only result of our criminalization of drug use is to create a tool to discriminate against people of color and minorities. Criminalization is not the answer. Until we treat drug addiction as a health issue, we will continue to make no inroads on this problem. The criminalization of paraphernalia will stop the spread of disease because there will no longer be fear of breaking law by those passing out clean needles. Furthermore, people will dispose of dirty needles safely if it is not against the law to have paraphernalia on them. A little over a year ago, I had the opportunity to take my niece to the Whitsitt Center in Chestertown for detox. I probably got this job because her family knew I wouldn't be swayed by her story that she didn't have a problem. The one thing that stood out for me that day while I was sitting on the plastic chairs in the waiting area was that this is about treatment, not incarceration. It's about helping someone that has an illness that needs to be treated. I would ask anyone on this committee to sit in the lobby of the Whitsitt Center any day or reach out to any of the intake workers and ask their opinion on this bill. Criminalization is not the answer. Finally, I've been a public defender for the past 22 plus years. I can tell you very few police officers today are still charging the crime of paraphernalia, and of those officers that are charging, the state generally doesn't follow through with those charges. Furthermore, 20 other states have decriminalized paraphernalia. I believe that this legislation allows the law to catch up with what is already happening in Maryland and other states in the United States. I'd ask for a favorable report. Thank you.
Good afternoon, Chair Smith, Chair Waldstreicher, members of the committee. My name is Dan Rabbit. I'm the Policy Director at Behavioral Health System Baltimore. We are the local behavioral health authority in Baltimore City and strong supporters of SB 327. This bill will reduce barriers to accessing harm reduction services. I've heard a lot about why these services are important, but I want to really emphasize what I think is one of the most important things, which is that harm reduction services build trust with people who don't have anyone else to trust, people who are living in the shadows, living very difficult lives. And harm reduction services, they prevent the spread of disease, they address litter, but that trust, that connection to like a human being who cares about you can really change people's lives. And when that trust is broken by being harassed by police officers or maybe getting arrested for trying to participate in these programs, it really diminishes what the effect that these programs could have. So SB 327 makes it easier to participate in harm reduction services like syringe service programs by removing the ambiguity about whether these objects are legal or not. At a time when these programs are under threat due to the federal government and policies by the federal government, Maryland needs to do everything it can to make these programs successful. So please support the Baltimore City administration and this initiative from them and vote favorably on SB 327. Thank you.
All right, thank you all very much for your testimony. Questions from the committee? All right, thank you all very much. Thanks. All right, Jesse Dunleavy. Thomas Higdon. And then we'll go to our virtual panelists. We'll let them into the room as well. But go ahead, welcome.
Hi, thank you for letting me speak in favor of this bill. I'm glad to be here. My name is Jesse Dunleavy. I'm a lifelong Marylander. My son, Paul, struggled with learning disabilities. He was kind-hearted and sweet-natured, but he didn't feel good about himself. His self-doubt in his 20s led to drug use, and the culture at that time was drug use is a crime and you are a criminal. You have no rights. So his hopelessness about his future only grew with each dehumanizing experience that he had. I'm thankful that since then we've learned a lot. We've learned that addiction isn't a moral deficiency. We've learned that punitive measures for those who don't violate the rights of others add disadvantage on top of disadvantage. In fact, caging people and making them unemployable traps them in addiction. We have acted as well, naloxone, drug test strips, initiatives credited with the recent reduction in overdose deaths. And we've known for years about the benefits of syringe service programs. They reduce overdose and spread of disease. They prioritize health and wellness. But knowing you can be arrested for possession of a clean needle is a deterrent. And overdose deaths have declined, but not among all communities. The annual report of the Maryland Overdose Advisory Committee cites the discrepancy between the deaths of white and black people, and they urge access to all citizens of these harm reduction and life-saving initiatives. Fear of arrest is well-founded because black people are more than twice as likely to be arrested. And so in the final days of my son's life, he wanted one thing, and he turned to me with everything. He wanted buprenorphine. It was not accessible to us at that time. I tried hard, and I struck out. These unfounded restrictions have now been lifted, not in time to save Paul's life. But I do think paraphernalia decriminalization is the same thing. It's just a common sense initiative that will save lives, and I urge you to pass it. Thank you very much.
You gonna abandon me? It's okay. I'm used to it. Chairman, Vice Chairman, members of the committee, my name is Thomas Higdon, and I'm the Executive Director for the Maryland Alliance for Sensible Drug Policy. We're a statewide membership-based group led by people with lived or living experience with substance use. I'm here today to support SB 327 because paraphernalia prohibitions do not stop drug use. Take it from us. They make drug use more dangerous, and those harms spill out into our communities. We asked some of our members to share what it looks like in real life, and here is what they told us. First, criminalization of paraphernalia pushes people to reuse and share supplies even when they know the risks. One member told us, quote, "Because I was in the thick of my addiction, the only option one evening was a dull needle that belonged to somebody who I knew had hepatitis C. And yet I still put it into my body. I have permanent nerve damage to this day." Second, paraphernalia criminalization keeps people away from health care. As one of our members told us, "I desperately needed medical attention, but I didn't want to go to the clinic because I was afraid of getting caught with my paraphernalia." Third, it encourages unsafe disposal of paraphernalia. And one member told us, "I was always afraid about being stopped with my paraphernalia on me. I would toss it at the first hint of trouble, often in parks or alleys or even along the sidewalk where anyone, including children, can find it. This haunts me to this day." And finally, the stigma around paraphernalia does not stay neatly confined to drug use. One of our members who had an experience being stopped by the police told us, "I'm a diabetic, and at the time I was using insulin with syringes. I've never been an IV drug user, so I thought being interrogated about them was never on my mind. The police were rude. They didn't even treat me like a human. I felt humiliated." It doesn't have to be this way. Not by pretending drug use is not risky, but by removing the criminal penalty that reliably makes drug use more dangerous for individuals in the public. For these reasons, we ask for a favorable report on SB 327. Thank you.
Thank you very much. Questions from the committee? The members that are left.
You'll pass the bill.
Yeah. If he's here to vote for it, I don't know. All right, we're now going to join, we've got a panelist joining us virtually. So we have Ms. Nesbitt, you're up next. Actually, Ms. Emerson, go ahead. And then we'll.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which works in partnership with Maryland Volunteer Legal Services to reduce the collateral consequences of criminal legal involvement for sex workers, survivors of human trafficking, and those populations put at highest risk of exploitation. I'm also here in support of Senate Bill 327. I'm here to make mention of a group who are not commonly thought of as benefiting from harm reduction approaches such as these, which are survivors of human trafficking. Drug use operates as both a common predictor of and reaction to this horrific crime. Studies have found that between 80 and 90% of trafficking survivors report self-medicating to cope with past trauma and were trafficked as a result of their addiction, while those who have survived a trafficking experience often begin using substances in an attempt to cope with what has happened to them. In particular, both medical and social service staff working with trafficking survivors have noted high rates of opioid use among this population, and as a result, these individuals are frequent users of the state's syringe service programs and unfortunately frequently criminalized for possession of drug paraphernalia as a result. This bill would decrease the risk of incarceration for these individuals while at the same time increase the likelihood of them using substances more safely, all of which protect them from re-exploitation. In addition, this type of harm reduction intervention serves as a form of human trafficking prevention for women who are currently using but have never been trafficked before, because it makes it less likely that they will have to live their lives in the shadows where exploitation thrives, as they merely try to figure out a way to use more safely. Harm reduction measures like Senate Bill 327 are important for all people who use drugs, including survivors of crimes like human trafficking. Equipping people to use drugs more safely works not only to stem the spread of infectious disease, but also to lift the stigma that so often isolates drug users, making them vulnerable to a whole host of additional harms, including exploitation. For these reasons, the HDPP supports Senate Bill 327 and respectfully urges a favorable report. Thank you.
Excellent. Thank you very much. All right. Now we'll go with Tony. Are you in?
I'm here.
Welcome.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and committee members. My name is Tony Dorsch, and I'm the director of the Daniel Carl Torch Foundation, named after my son who passed away from an overdose. We are a small nonprofit community organization. We're based in Baltimore County. I retired from the Department of Juvenile Services after 40 years in 2022 and have run our foundation, our organization, for the past 15 years. One of our responsibilities is providing various types of safe use supplies to people who use drugs. And I use the word responsibility because, to tell you the truth, it's really not what I want to be doing, but I know it's what we have to do. We have to do this in order for our communities to see the reduction in spread of disease, additional harm to themselves, and the left behind debris. We have about approximately 2,000 engagements each month. You've heard plenty of facts today. It's been a long day for you, and this bill just makes sense. But I do have 3 things to add. One, I do want to share with you that even community organizations fear those interrogations of local law enforcement when they observe our paraphernalia being distributed. We've been followed to our homes. One male staff was pulled from his car, and one was threatened with arrest. The police officer stating that's some Baltimore City BS. You're in Baltimore County now, son. Please trust in us. Trust in the boots on the ground, on what we encounter, on what we see, and we have our thumb on that pulse. This committee, your committee, has helped move Maryland forward in many ways by supporting bills into law that has had a tremendous positive impact on all of our communities. My previous invitation to any elected official to accompany our team for a visit in the community stands. I respectfully request a favorable report for Senate Bill 327.
Thank you very much. All right, Ruth Carlock, you're next.
Thank you. Good afternoon, committee members. My name is Ruth Carlock, the legislative liaison at the Brain Injury Association of Maryland, and I'm here in support of SB 327. Brain injuries, including those resulting from overdoses, represent a significant public health concern. Substance use disorders can lead to overdoses that deprive the brain of oxygen, resulting in lasting cognitive, physical, and emotional impairments. While research highlights the correlation between substance abuse, overdose incidents, and the risk of acquiring traumatic, anoxic, and hypoxic brain injuries. The connection between substance misuse and brain injury is strong, with a notable proportion of individuals in acute rehabilitation for brain injury being due to drug and alcohol use. Researchers in Canada found that individuals who had experienced an overdose were over 15 times more likely to suffer brain injury compared to those who had not, noting the correlation between these two issues. And in 2023, Governor Moore created the Office of Overdose Response to tackle the overdose crisis. This legislation would strengthen those commitments by making Maryland a safer place for first responders and healthcare professionals, while continuing this administration's push of treating addiction and substance use disorders as the public health crisis they are, instead of a criminal justice issue that perpetuates these issues. To quote Governor Moore, we are focusing on expanding pathways to compassionate care for individuals, whether they are actively using drugs or are on the road to recovery. Building communities that can thrive requires ensuring that all Marylanders, regardless of where they come from or where they are, can access the supports they need. This bill would eliminate the criminalization of several of the most important harm reduction techniques utilized in the reduction of overdoses, from the testing equipments of drugs like fentanyl or common syringes used in weekly medications. Syringe services programs reduce needle litter, keep public spaces cleaner, and reduce the spread of STIs. These programs are also more effective in states without the criminalization of drug paraphernalia, leading to a higher engagement in recovery treatment. SB 327 addresses a critical component of brain injury prevention for individuals with substance use disorders, and we urge the committee to render a favorable report, and thank you for your consideration.
Excellent, thank you very much. All right, we'll move on to Jess Nesbitt.
Hello, everybody. Good afternoon. Thanks for the opportunity to testify today. My name is Jess Nesbitt. I also go by Red. I'm a therapist, social worker, and I love people who use drugs. I also happen to work at Healthcare for the Homeless. You heard from my colleague earlier, and I want to testify in support of SB 327. Yeah, we live in a world where things change moment to moment, and I think clarity is a real gift, and that is what I see this bill offering, is clarity, like free, no cost clarity. The laws as they stand are really confusing, they keep people from coming and getting services like therapy or primary care or other really life-saving care. And when I think about people that come to see me and my colleagues, I see all the ways in which they're working really, really hard to survive, all the ways they're caring for their health and those of the people around them too. And the last thing they and anyone needs when they are trying to get healthcare is to walk away from the clinic or the org or, you know, the encounter with lovely harm reduction staff and get arrested for possessing things that are legal. And I'll say it again because it is confusing. Under current law, as I understand it, people can get arrested for possessing items that they legally obtain. So this bill will help people get connected to care and clear up our confusing laws. Thank you for your time.
No, thank you very much. Thank you for your testimony. We'll turn to the committee for questions. All right, seeing none, we'll now move on to, I think that'll conclude the testimony for the proponents of the bill. We'll now move on to the opposition panel. Mr. Williamson? Mr. Morrow? Yeah. Morrow Williamson. There you go. Hey.
Good afternoon, Chairman Smith and members of the committee. My name is Moreau Williamson, and I'm an assistant state's attorney here in Anne Arundel County, Maryland. I've been a prosecutor for 18 years, and I've been assigned to the Felony Narcotics Unit for the past 11 years. I'm testifying today on behalf of the Maryland State's Attorneys Association. The Maryland State's Attorneys Association opposes SB 327 and urges this committee to issue an unfavorable report. SB 327 would completely decriminalize all drug paraphernalia used to consume, store, weigh, package, manufacture, and increase the volume via cutting agents of controlled dangerous substances. Devices used to ingest drugs, whether by injection or inhaling, would be legal to possess, leaving law enforcement with limited options to address public drug use and restricting their ability to intervene and connect those struggling with addiction with treatment. Drug courts and probation that includes drug treatment is a better way to address substance abuse than to decriminalize all drug paraphernalia. Items used to distribute and manufacture controlled dangerous substances would also be legal to possess. This would hinder the ability of law enforcement to investigate possession with the intent to distribute and manufacturing crimes. This would also decriminalize all of the tools used by drug dealers to sell their poison. So we're talking gel caps, baggies, cutting agents, scales. This bill goes too far. While the MSAA was in favor of harmonizing the penalties for drug paraphernalia in the last legislative session, and is certainly in favor of helping people struggling with drug problems find treatment and get better, unfortunately, this sends an unfortunate message about drug paraphernalia in general. If this bill is about addressing syringes and safer use, then write a bill that addresses that. Do not write a bill that completely throws out 5619 and 5620. 5620 in particular addresses items associated with the sale of drugs.
Thank you very much.
Sure.
All right, questions from the committee? All right, seeing none, thank you. With that, that'll conclude the hearing for Senate Bill 327. Before we move on to the next bill, I just want, just as chair of this committee, I want to apologize on behalf of the committee because of the lack of attendance of some of our members. We all run for office. We ask for this job. You all come from all across the state to come here to petition your government for change, and part of our core responsibility is being here to listen to your testimony. And so I know that some members have medical emergencies, dealing with family issues. Some members are just going to committees to testify on other bills. So that obviously that's part of our responsibility. But we do owe it to you to be here as much as possible when we're not attending to our other official duties during session. And so I want to say, you know, my apologies. We will endeavor to do better. That's my promise. So I just want to say thank you all for being here and for providing testimony. It was not, you know, not in vain, and your testimony was received well from our committee. So thank you very much for you hanging in here with us. But this committee will do better. I promise you that. So thank you all very much. All right. With that, we're going to move on to Senator News.
Thank you for saying that. Thank you.
Thank you. Yeah, thank you. We're going to move on to Senate Bill 320.
Thank you, Mr. Chairman. Thank both of you. Senator Sidnor, thank you very much. For the record, I'm C. Anthony Muse, and I represent the 26th District in Prince George's County. I think I have a panel here, Megan McDermott and Melissa Rothstein, an attorney. If they're here, they can come up to the table. This bill is a technical fix to the expungement statute that will allow charges designated as a no finding to be eligible for expungement. The bill was voted out of the House last year, but did not move in the Senate because our partners in the district court wanted to review it during the interim to ensure proper implementation. I'm happy to say that those conversations have happened, and the bill before you is a final project of our collaboration. First, a reminder of why this bill is needed. Under current law, expungement is available for acquittals, dismissals, and a limited selection of misdemeanors and felonies. In Prince George's County, many residents have a unique disposition called no finding, which is not enshrined in statute and makes them eligible for expungement. Before the Justice Reinvestment Act of 2013, certain judges in our county used no findings to prevent individuals from being convicted of minor crimes. Thus, we have a large contingent in Prince George's County with charges that would be eligible for expungement under normal circumstances, but are not due to this unique disposition. Senate Bill 320 is a technical fix to the expungement statute that addresses the no finding disposition. It makes it eligible for expungement in accordance with the intent of the judicial officials who created the designation. My panel will address some of the particulars of this bill, as well as the conversations with the district court. And with that, Mr. Chair and others, I urge a favorable report. Whoever wants to go.
Good afternoon to the committee. Thank you to the senator for introducing this bill. My name is Megan McDermott. I'm an advocacy director at Maryland Legal Aid. I've supervised our expungement practice for many years. Senate Bill 320 would allow expungement of no finding and case terminated without finding dispositions. These dispositions function as convictions, but because they're not typically used in Maryland, they were never incorporated into the expungement statute. So why are we talking about these dispositions that are not part of Maryland law? Well, thousands of people whose cases were adjudicated in Prince George's County are faced with a bizarre roadblock to expungement. For decades, these individuals were asked to plead no contest in criminal proceedings. Usually in Maryland, such a plea would result in a guilty disposition. But in these cases, a no finding or a case terminated without finding disposition was entered. This practice went on for decades, likely in an attempt to give folks some relief from being associated with a guilty disposition. However, since that time, Maryland has expanded its expungement statute, and it includes convictions. The tangible impact of expungement greatly surpasses any positive gain from receiving an obscure disposition like a no finding. And so individuals who received a no finding, who in effect received a guilty disposition and served their sentences and are otherwise eligible for expungement, have been left behind without access to expungement. It's pretty clear that this is unfair. People should not be penalized because of a rogue legal practice, no matter how well-meaning. Senate Bill 320 does not expand the world of charges eligible for expungement. It simply allows cases with these specialized dispositions to be expunged using the same standard as convictions. Please report favorably on Senate Bill 320 so all Marylanders have equal access to expungement and therefore to economic stability. Thank you.
Good afternoon. My name is Melissa Rothstein. I'm an expungement attorney for Out for Justice, and I urge you to issue a favorable report on Senate Bill 320. Out for Justice is a grassroots advocacy organization led by individuals impacted by the legal system that advocates for policies that reduce recidivism and promote second chances and successful reintegration into society. Expungement reform is a high priority for Out for Justice, an important component of successful long-term reentry. I don't want to repeat. I think the senator, as well as Ms. McDermott, have really laid out this is a technical fix, and an important one. I just want to highlight. Last year, I worked at the Public Defender's Office, and at that time had gathered information about the number of cases that were impacted. And working with the leadership in the Prince George's County office, we determined there were about 15,000 cases that are impacted. And these were all cases in which the judge was intending to give people a disposition that had fewer penalties than a guilty conviction. And so this would really be is an important measure to further what that intent was and to put these individuals on equal standing. So for those reasons, I hope that this I ask that this committee issue a favorable report. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you all very much. Thank you, Senator. Thank you. All right, that'll conclude the testimony for the proponents of the bill. We'll now hear from Mr. Cox.
Thank you, Chairman Smith, Vice Chair Waldstreicher, members of the committee. I signed up as an opponent because favorable with amendment was not an option. And so that's why. So I'm opposed to the way that it's worded. We are absolutely in support of the principle. I agree that these individuals are being treated unfairly. When I read it, I was like, I don't even know what this is, and then learned that it's peculiar to Prince George's County, and learned a little bit about it. My concern is, and the concern of the State's Attorneys Association, is the way that the bill is worded. I did submit written, which suggests another way to word it. Because the way it's worded now, one could create an interpretation that this would apply to any crime, even if it wasn't eligible under 10-110 for expungement. So our suggestion was that you in effect say, and it's in my written, but that you in effect say that the word convicted in 10-110 would also include a no finding or terminated without finding. That will create the eligibility for those individuals affected by this the same as everybody else who had been convicted for the particular type of offenses that they were convicted of, and still go through the appropriate process under 10-110.
No, I appreciate that. Thank you for that.
Okay, right. Great. Yes, sir.
Questions for Mr. Cox? All right. Seeing none, thank you very much. Thanks for hanging in there with us. All right, with that, that'll conclude the testimony in the hearing for Senate Bill 320. We're now going to move on to Senator Sidnor 321.
Is that right?
Yes.
All right. All right. If you were to look at the bill, Senator Sidnor for Senate Bill 321, it's a very simple bill, and I know many of you have heard that at times, but this truly is. In 2015, my first session, one of my first bills that we passed was to create the framework for body cameras to be used across the state of Maryland. Just a few years ago, we expanded the wearing of body cameras by law enforcement to capture most law enforcement officers across the state, but we did not capture everybody, and that's what Senate Bill 321 is about. Senate Bill 321 is a minor but necessary change to our law. So current law requires each law enforcement officer who regularly interacts with members of the public as a part of their official duties to use body cameras. Law enforcement departments like Maryland State Police have interpreted officers who regularly interact with the public to include most members of the Field Operations Bureau, as well as SWAT team, but not command staff or certain special division officers, like those in the licensing division. Commanders can routinely become involved in critical operational incidents, such as protests, mass casualty events, or police shootings. These events, such as the 2025 incident in which a Chevrolet police chief shot and killed a suspect in Prince George's County, provide evidence of the urgency for this legislation. Officers should be held to a high standard regardless of rank. Senate Bill 321 alters the law slightly to require more officers to wear body cameras. Under Senate Bill 321, all sworn officers who are in uniform in the public and conducting law enforcement-related duties will be required to wear body cameras. Every officer's encounters with the public should be subject to that same clear documentation provided as a body-worn camera would, regardless of the officer's rank or division. The Police Executive Research Forum reported that body cameras improve officer professionalism and allow agencies to identify larger structural issues within their department. One of the things that I wanted to note, and I think that's beautiful about the law, and I'm going to joke with our FOP president here, back when in 2015 when body-worn cameras, the legislation was introduced, they didn't support them. But we're here today jointly supporting this legislation. And with that, I'm going to sit down and ask for a favorable on Senate Bill 321.
I was just happy to see you all in the same panel for once. It was good. It was good. Yeah.
Hi, good afternoon, Chairman, committee members. My name is Lieutenant Elliot Cohen. I'm here on behalf of Baltimore City Fraternal Order of Police, Lodge Number 3. Simple bill, as the senator mentioned, is to essentially have members of any rank follow the same requirements as rank and file members. I don't need to tell you guys about the virtues of body-worn cameras. Our membership are true converts to the technology. We wouldn't hit the streets without it today. And it's a little hypocritical for commanders to espouse the benefits of the body-worn camera and then exempt themselves from those responsibilities. It's something we see more often today, is that the higher somebody becomes, they are actually held less accountable. It's one of those things where we frequently see of, rules for thee, but not for me. There's been a couple concerns about coverage, saying, oh, this will require commanders to record community meetings and their discussions with the public. That's not true. It's just the same requirements that officers have to follow. Officers don't have to record community meetings. It's just these law enforcement things. And there's also been some concerns about costs, which I want to address. One is the cost of storage. If commanders are going to be recording so many things that it's going to significantly increase the cost of storage, then they probably should have the cameras already. It means these things are not being captured and there's a lack of transparency. If it's the cost of cameras, keep in mind that many of these commanders are given $50,000 SUVs for their personal usage to drive to and from work. I'm sure these agencies can afford the $200, $300 camera for those commanders. This is a simple fairness. If a rank and file member can do it, I'm sure a commander can too. Thank you for your time.
Good afternoon, Mr. Chair, members of the committee. Again, my name is Clyde Boatwright, President of the Maryland State Fraternal Order of Police, representing the approximately 21,000 law enforcement across the state of Maryland. We stand in support, unified in support of this piece of legislation. Again, you've heard it a number of times, it's a simple fix. I can proudly stand before you and say in 2015, I was totally against body cameras. But as a police officer when I'm on the street, I can't wait to review the footage of my encounter with a member of the public, because I want the story to be told. As we are working through still building and establishing trust across communities, this tool has saved more officers than it has prosecuted. So, the story, the vantage point of our police officer has been now shown to the world. And we just think that everyone that is going to take enforcement action, whether that's a car stop or whether that's responding to a in-progress call, their point of view should be captured and be available. So with that, on behalf of the Maryland State Fraternal Order of Police, we do stand in favor of Senate Bill 321, and it is good to sit finally on the panel with Senator Sidnor, because we usually have a little opposition sometimes. So thank you. And I'll stand for any questions.
Thank you very much. I'm going to play the lottery tonight. That's what I'm going to do. All right. All right. Seeing no questions from the committee, thank you all very much. Sorry. Hold on. Sorry. I know we got some people going remote. So actually, let's hear from Ms. Levy first, and then we'll hear from Daniel Franklin, and then we'll open it up for questions.
Sure. Thank you very much, Senator Smith. I'll be very brief. This is Debbie Levy from the Maryland Office of the Public Defender. We urge a favorable report for SB 321. Also, it's a strange day for us to stand in solidarity with the Fraternal Order of Police and Mr. Boatwright's recommendation. From a practical standpoint, BWCs have been helpful and hurtful to both criminal defendants and to law enforcement. The jury is still out on which group benefits more. But what we know for sure in this day and age, they're an absolute necessity. We use them to evaluate the propriety of stops, the propriety of searches and seizures, and unfortunately, in cases involving a death related to a law enforcement officer, we use them in those circumstances. And as Mr. Boatwright testified to, they have actually been used to exonerate more officers than not. Maryland has come to expect them and rely on them. I remember the legislative discussions around the Police Accountability Act of 2021, and the talk at that time was folks wouldn't be able to afford them. Let's start slow with some large jurisdictions. We did that. The law then said that by 2025, everybody would have them. Every agency now has them. Even I think the Natural Resource Police were the last ones, and I think that they mostly have them. Every jurisdiction in Maryland uses them and has policies around them. And there's really no legitimate or rational reason to not then fully require them for every sworn officer if we're going to actually enact fully the Police Accountability Act and demand transparency and accountability. So for those reasons, we would urge a favorable report. Thank you.
Is he in person, Mr. Franklin?
Yeah.
Oh, come on in.
Okay.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the committee. Dan Franklin, Police Chief, Morningside. I'm here on behalf of the Maryland Chiefs and Sheriffs Association, and I provide testimony of supporting with amendments for Senate Bill 321. First and foremost, as the police chief of a small Prince George's County municipality, just require clarity on a couple things. When I'm in uniform, that is in public, 100% of my time when I'm there. When I am out on the road, when I'm doing enforcement, handling calls, backing up officers on calls, I wear my camera, no questions asked. The bill doesn't offer any clarifying information on what law enforcement related duties are. I know there's been some discussion. I've heard the previous testimony. We offered written testimony. I did myself, and the chiefs and sheriffs did, as to what they feel that law enforcement related duties should be. Any body worn camera stuff comes at a cost to the agency. Adding for some may not be a heavy lift. For some, it may be the difference between a terribly strained budget and a broken budget. Because each body worn camera comes with the user license, storage, not to mention the hardware costs. And as we all know, majority of police budgets are funded by the constituents. So it could have a very big impact. The biggest amendment that I could say is law enforcement related encounter. It does not include the casual greetings given to the public, an encounter where the member of the public seeks information, directions, et cetera, or anything that's not currently required to be recorded by the adopted Maryland Police Training and Standards Commission model policy that currently exists. Might have some conflict with the judiciary as well. I have about 10 more seconds if I could have that, sir. Okay. just the current body-worn policy says that at the initiation of a call for service or other activity that is investigative or enforcement in nature, and any encounter that becomes confrontational after the initial contact. I don't believe that those criteria are bad criteria. The other question becomes mandating everyone to have a camera. Again, I don't think we, as an organization, have an issue with that, provided there's some funding assistance. Obviously, that's a given. But I would suggest if you guys have, I know you had my written and the organization's written testimony submitted for clarification. If I tried to talk about that, we'd be here for a month of Sundays, and I certainly don't want to do that.
Thank you, Mr. Chair. For the sponsor, thank you for your leadership on this from the very beginning. I remember standing with you and telling our friends in law enforcement that this is actually going to benefit them as well, and pointing them to examples around the country. And I'm very glad that those have really come to fruition. Isn't that so?
Isn't that so? And this was at the time when you were with the ACLU of Maryland, absolutely.
Thank you, Mr. Chair. Thank you for the bill, Senator. I just wanted to ask you, is there a reason that you were specifically only including in uniform? Like, would you be open to like some prescriptive language for, like, you have your investigators that go out after a crime scene and they're walking around in plain clothes and they're capturing important data and information and interviews and all those things? I just am curious because that's a pretty significant.
You think we're limiting it by saying
Well, I
uniform?
mean, yeah, I mean, because you have in there specifically law enforcement.
Right. No.
Or I mean, I'm sorry, specifically in uniform. I'm sorry.
Right. This language is, with most of my bills, is the language that was put forth, but always open to
Okay, we can just talk on the side.
Yeah, absolutely.
Thank you.
Sure.
All right.
And if I may say, just for some clarity's sake, if one looks at page 2, lines 6 and 7, current law, it speaks to a law enforcement officer's official duties. The new language, which is on line 7 and 8, speaks to conducting law enforcement related duties. I would say that those phrases are essentially the same and which should be treated the same. With that, thank you.
Thank you very much. With that, that'll conclude the hearing and the testimony in the hearing for Senate Bill 321. We'll now move on to the Vice Chair, Senator Waldstreicher, with Senate Bill 315.
Thank you, Mr. Chairman, members of the committee. This is a technical fix regarding expungement. So when we created the expungement statute, expungement is the highest level of obliteration of criminal records. And because it completely obliterates it, we didn't specify in the law that you are not responsible for putting that on any application for a state license or for admission to a university, because we thought that was inherent in what we were doing. There is no record of the crime, and everything is fully obliterated. When we created the shielding statute, which is a lesser standard than expungement, it was a little unclear of whether someone would have to put that on a license application for state licensure or a university application. And so we made clear in the statute that you do not have to put that when you are applying for a license, and that can't be the sole reason by which you are rejected for university admission or a state license. This creates an awkward drafting circumstance where it's in the shielding statute, which is kind of the lesser of the two options, but not in the expungement statute. So this technical bill makes clear that the same rules that apply for shielding apply for expungement when it comes to application to state universities and for state licensure. There was some extraneous language that was added to the bill. That was my fault with the miscommunication with the House sponsor, Delegate Moon, and it relates to MDEC. So we have an amendment. It's amendment number 653520 that removes the MDEC language and keeps only the technical language. And if this were to come before the committee, I would offer that amendment. There is in your packet something I have not received frequently, a racial equity impact note that makes clear that this technical change of language is in the interest of racial justice. With that, Mr. Chairman, I'll ask for a favorable report on Senate Bill 315.
Good afternoon again. I am still Melissa Rothstein, an expungement attorney with the office with Out for Justice. And thank you, Senator Wallstreicher, for bringing this bill, and for members of the committee. Expungements are critical to ensuring that after someone has done their time, they can become a fully contributing member of society. Criminal records provide insurmountable barriers to employment, housing, and economic stability well past when someone has served their time. Among the reasons why expungements are so important is that they can remove these barriers. However, the expungement is meaningless if the refusal to disclose information about the charges can be a basis to deny education, a license, permit, registration, or government service. Senate Bill 315 seeks to codify the true intent of expungement law to remove the case from a person's criminal history. While much of the focus of expungements is on document destruction, requiring the person to verbally disclose the events would defeat that purpose. Once again, I want to thank Senator Wallstreicher for bringing this bill, and I urge you to issue a favorable report.
Good afternoon to the committee. Thank you, Senator Wallstreicher, for introducing this bill. I'm Megan McDermott. I'm an advocacy director at Maryland Legal Aid. As my colleague, Attorney Rothstein, has said, Senate Bill 315 codifies protections against the collateral consequences of criminal records by precluding the state and educational institutions from discriminating against people who have expunged records. I started working with expungement clients at Maryland Legal Aid almost a decade ago, and over that decade, this legislature, many folks who are sitting in this committee, have voted to broaden the expungement code many times. These changes reflect Maryland's values, that people deserve a second chance, and that mistakes shouldn't impede a person's ability to better themselves by engaging in training programs or furthering their education. After Maryland Legal Aid closes a client's expungement case, one of the most common questions clients have is about disclosure and applications. They want to know if their cases are really obliterated and if it's really okay not to disclose them. This bill helps clarify that schools cannot refuse to admit or expel someone based on an expunged record, and that applies as well to applications for government services. This ensures that Marylanders can fully participate in civic life. Please vote favorably on Senate Bill 315 for these reasons. Thank you.
Excellent. Thank you all very much. Questions from the committee? This one from Senator Love.
Thank you, Mr. Chair. Thank you, Mr. Vice Chair, for bringing this bill. I have, over my years as a legislator, supported expungement. I do have a question, though. There was an article in the Banner just yesterday, I don't know if you saw it, about someone who pled guilty to sexual assault. He was required to register as a sex offender. And then he got his record expunged, and 5 years later, he was hired by Baltimore County to be a police officer. And the person that he assaulted saw him, and she was re-traumatized. And she thought, you know, if I had to call police to help me, and the man who assaulted me showed up, I can't imagine how horrifying that would be. So how do we do what you're intending to do here and yet protect victims, especially those victims of sexual assault?
So I haven't seen the article. I am unaware of any sexual assault criminal conviction that is expungible, but clearly there is something here. So
it was a plea deal. Was it a PBJ? Yeah, I think so. Yeah.
Yeah. Well, please, yeah. If that's okay.
Oh, go to podium. Okay. So
I'll share the article for the committee.
I know we had discussed, I think we both have slightly different responses, but one of the things I would say is the fact that something is expunged doesn't then entitle you to a job. And really for the police department, there are more things that should be done than looking at a background check. I'm not familiar with the specific circumstances, but from what I read in the newspaper, this was something that resulted in an an at-cause termination and occurred while this person was at work. So if there was a basic reference check, whether whether there was a criminal history or not would not have been relevant. And so I think in terms of using this example to sort of suggest that then expungements need to be, that sort of need to be reconsidered, I do think that some of it is sort of looking at also what is the process that's actually happening for people to be hired beyond just a quick background check look.
Okay, to be clear, I wasn't saying we need to look at all expungements. I was trying to figure out how if we are going to make sure that it's not, may not be the sole reason for an employee of a state or political division to deny a person's application for a license, how do we make sure that this type of thing doesn't happen? If there's somebody out there who has this type.
I mean, I would say, a license is different than a job. And so, and I'm not sure that the fact that somebody has this means that they can't get any type of license. That's very different from becoming a police officer. And so I think particularly looking at it in the circumstances of this particular bill, and I believe that you'd mentioned that this was a probation before judgment, which wouldn't even be impacted by this bill. I do think that it's taking one sort of piece of information and using that to sort of as a decisive thing for a much larger issue that isn't necessarily that isn't necessarily focused on whether somebody would have to disclose an expunged conviction or not.
The only reason I bring up the PBJ is because I don't understand how else you would get like a 4th-degree sex offense expunged. I mean, he must have had a PBJ for it or something. I don't know.
Yeah. Right. And this, well,
I don't know.
Yeah. Yeah.
We'll figure it out.
Just to add, as Ms. Rothstein was saying, the individual in the article, which I read and was horrific, was a firefighter when the original incident happened in Baltimore County. So I do think there was, perhaps a miscommunication there about switching from the fire department to the police department. This bill, though, is only about changing the law to allow people to go to college, essentially, and to get licenses. It doesn't impact any employment. That is already in the law, but this doesn't, impact that at all. And I would say that, this one individual situation, again, is horrible. But we don't want to deny the many people who do have minor offenses that result in PBJs, which is how you usually get a PBJ, to be prevented from going to college and furthering their education. So just something to think about there. And I think also the situation just highlights the way that we've really failed women and girls when it comes to responding properly to sexual violence and other abuse. And I don't think this bill, though, is the way to address that. But I know at Legal Aid, we represent survivors and protective order hearings and many other types of hearings addressing abuse. So we'd be happy to talk about ways that we could address those systemic challenges in another forum.
All right. Seeing no further questions, thank you all very much. With that, that'll conclude the hearing for Senate Bill 315. We'll now move on to Senator Folden with Senate Bill 330.
Mr. Chair, Mr. Vice Chair, esteemed colleagues, Judicial Proceedings. For the record, William Folden, State Senator representing Legislative District 4. Before you today, have SB 330, dealing with the public safety and police accountability and investigative records relating to not administratively charged, unfounded, and exonerated complaints. Similarly to the bill we just heard, although in those circumstances we're talking about criminal offenses, I wanted to point out that I thought it was very telling that we have people coming in and testifying that we should be looking to give people a second chance after a criminal conviction. But when we have police officers that are investigated and they're exonerated of not criminal investigations, but administrative investigations, this body has taken the stance that they will not remove those records from public review. I find this very, it's a high burden when we're talking about the hiring of police officers these days, because we're adding so much more onto their role and responsibility. They're not just law enforcers, they're counselors, they're first responders, they're medics, they're psychologists, they're doing all these different roles and making split-second decisions. Sometimes people get upset when you enforce the law. I know that's going to be a difficult concept, but it happens. People get upset when they break the law and they get arrested. Whether a complaint is justified or not is irrelevant according to the Maryland Police Accountability Act. The complaint can be unjustified and it could be seriously inflammatory. They could make serious accusations with little or zero recourse by the officer. And this body then took it upon themselves to make not only are those reviewable, but they are also available for public review, and there is no limitation on what the public can do with those records once they get them. I ask any of you in your current job, if you've ever been counseled, how would you like to have a bill that allowed the public to review your personnel file, and when you made a mistake, a human mistake, or didn't make a mistake at all but were investigated? Actually, this bill only covers when you didn't make any mistake and were fully investigated and exonerated. How would you like it if your public, all your friends, were able to grab that bill, put it up online, make whatever inflammatory rhetoric they want about it for your children to see, and we wonder why we have recruiting issues and retention issues in law enforcement in Maryland? I think this is a very reasonable first step to get back to a decent balance of, we want accountability. Transparency is important. The cameras that we have now, and again, with the senator from Baltimore County bringing additional language, those have created a transparency, a trust factor back into somewhat with the communities. But we're still seeing so many complaints, unfounded, as a result of the cameras, but those officers have zero recourse to remove such complaints from their file. I find it wholly unfair that we put these officers who put their life on the line for us in a category that does not allow them the opportunity to have frivolous, false, and sometimes just downright lies submitted about them, only to be a lot of times shown in a body camera to have zero value, and people can take that information and distribute it out on the internet just because it was written by somebody else, anonymously at times, and there's zero recourse for that officer. Zero. Let's add some civility back to the people that are our protectors, and this legislative body, as the lawmakers, have an opportunity to do that for our law enforcers. I would recommend and ask for a favorable report on SB 330. There is two minor amendments that I did submit with it. The first one would be on page 2, line 18, under subsection C, where it talks about the police officer's personnel records. We would add in expunged and or destroyed after, 3 years after. And then on page 2, beginning of line 24, insert under move paragraph 2 to paragraph 3, and then insert under paragraph 2, a law enforcement agency issues a determination not to administratively charge a police officer in connection with a complaint of misconduct not involving a member of the public. We all know that any circumstance or situation involving a member of the public must be investigated. However, there are times where someone comes in late or tardy or whatever it is, and it's unsubstantiated, and they decide not to pursue the complaint. This would also give them recourse. So with that, I've asked for your favorable report. I'll turn it over to my panel.
Good afternoon. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we're requesting a favorable report on Senate Bill 330. In 2021, the General Assembly passed and did a complete repeal of the Law Enforcement Officers' Bill of Rights, and in came the Maryland Police Accountability Act, which became effective in July of 2022. The repeal of the LEOBR included a repeal of the ability for a law enforcement officer to have any of his complaints that were either unfounded, exonerated, non-sustained, or found not guilty of a trial board to be removed from their file. The way the law reads now, as the senator just stated, no matter what the complaint is, The Administrative Charging Committee, which is an independent body completely separate from the police department, if it involved a citizen, they have the opportunity to review that case. If they make the decision not to charge the officer based on exoneration or unfounded, that report and that investigation still stays in that officer's file. The amendment that the senator just spoke about would also include those cases that don't involve a citizen that are done by the police department. I've been doing this a long time. I represent officers every day. I did 6 statements yesterday, and of the 6 statements I did statewide, 4 of them I already know are going to be unfounded. Some of the complaints we see are extremely serious. A criminal act was against them. The officer used profanity. When all of this is captured on body-worn camera, reviewed by an independent administrative charging committee who determines there's nothing there, it didn't happen. But if you go pull that officer's record, it's going to show he was accused of very serious misconduct, even though there was nothing to it. We don't believe there's any reason that that should stay in their record. Police officers are the only public employees that have the ability, or unfortunately, these records are open to the public. And for that reason, we would request a favorable report on Senate Bill 330. Thank you.
All right,
Good afternoon, ladies and gentlemen, committee. My name is Mike Shire. I'm with the Anne Arundel County Fraternal Order of Police and Maryland State Fraternal Order of Police, requesting a favorable report on Senate Bill 330. Senator Folden really stole most of my testimony, to tell you the truth. So I'm just going to hit on a few quick things. Over the past few years in this chamber and across the street, there's been a lot of talk about expungements, and we just had a bill a few moments ago. So over the past 3 years, we've had House Bill 1448, 268, 867, 658, 73, Senate Bill 11, 602, and 1030. In 2025, we had House Bills 545, 318, 499, 621, and Senate Bills 398 and 432. And this year we have House Bills 113, 131, and Senate Bills 483 and 315. There seems to be a lot of talk about giving second chances to people who have committed criminal acts. We're not even here asking for a second chance. These are cases where police officers did nothing wrong, and it was proven that the officer did nothing wrong. Yet we still have this accusation on our record, and we're not even asking for it to be expunged right away. It will sit there for 3 years, open to public inspection, and then it will be expunged. It is not easy being a police officer. A number of years ago when we were doing the Maryland Police Accountability Act hearings, I remember Senator Jill Carter sitting over there telling me that the MPAA was not for me because I was a good police officer. It was about the bad police officers. And my entire 22-year career, I've strived and will continue to strive to live up to that characterization. But I'm still subject and have been subject to completely unfounded and false complaints. When a complainant comes in and says, yeah, I complained, but the officer really didn't do anything wrong. Why should that live on my record ad infinitum? It is incredibly difficult to do this job. We are having incredible difficulties hiring and retaining qualified police officers so that we can provide the level of service that our communities deserve. Please take a little bit of pressure off us and report favorably on Senate Bill 330. Thank you.
Thank you both very much. All right, we'll turn to the committee for questions before we switch to the opposition panel. Senator James.
Yes, thank you. I wasn't here in Annapolis when some of this was passed, so I just want to understand, we have 2 components to the bill. We have where's the text of the bill? Sorry, better if I find it. Here we go. So there could be a complaint of misconduct by anybody from the public, I guess, or anywhere else. So that's one thing. Yes. And then, as I understand that does trigger a police investigation first.
Yes.
Then the police investigation goes over to the Administrative Charging Committee.
If the complaint involved a member of the public.
Okay. And since this bill is as broad as that, it would include that. All right. So then they make a determination
Yes.
as to whether to proceed with charging.
They review the entire investigative file, body-worn camera. They have the right to call the police officer in to talk to them. Okay. They make the decision to either charge or not charge.
Right. Right. It's not quite the same as a trial, just because you don't have the same burdens and whatnot. And I don't think they exonerate a police officer much as just decide, for a variety of reasons, we're not going to charge the police officer.
There's two provisions. They decide not to charge.
Okay.
And then they can indicate that the officer is exonerated, which is defined in the Maryland Police Accountability Act, which means a police officer acted in accordance with their policy, or they can indicate that it's unfounded, and that's defined as the allegation against the police officer was not supported by the facts.
Well,
that's already defined.
Both of those are stronger than what I understood the way the bill sounds. It's just like, well, we decide not to charge, but really they're making an affirmative of one or the other. So it's a little more powerful than that. Now, when this police accountability bill was done, drafted and heavily discussed, did the conversation about not allowing for expungement or keeping these out there was even a thought in people's minds, or do you feel like it was more an oversight? We got a lot of fish to fry. We didn't get to that particular item, and now we can see that it's very important with a lot of police officers getting complaints and being exonerated and are found, the charges are unfounded.
What basically happened back in 2021 is when the decision was made and voted on to repeal the LEOBR, the provision for expungement was part of the LEOBR.
Okay.
And with the LEBR, the expungement process went away also, and there was no discussion when they created the MPAA of bringing the expungement ability back.
Well, so that's powerful as well, because it means that it wasn't discussed.
No, it was not.
And that's, so I think we might be able to view it as an oversight. Since that has all happened, have you or anyone else, I don't know if this is the first time we've looked at a bill like this. Have we looked at bills before asking us to consider something similar?
This same bill came in, I believe it was last year or the year before, but this is the only bill similarly written as it pertains to this.
So have you learned anything about whether or not now people are saying, and I'm not talking about the public defenders at this moment, just the legislators, people involved in the drafting, have you learned that people were like, we should have put something in, or we deliberately didn't, or no, we absolutely do not want these expunged, which I think should require language more than an absence of language.
I think it got caught up in the big picture of repealing the LEOBR, and there were many members of the Senate and the House of Delegates that wiped out the LEOBR and really tried to avoid putting any provisions of that back into the new law.
Are you aware of any, and you may not be, I'm not sure if I am either, I do not know if there are other states that have some accountability and whether they have addressed exoneration and or unfounded charges and the whole issue of having public records even after you've been exonerated or the complaint has been found unfounded. Are you aware of anything?
I can't tell you about any other state. I only know that in Maryland, prior to the repeal of the LEOBR, with all the changes in 2021, the internal affairs records of police officers went from being confidential to now being public. And I get emails every week from officers because the way the law is written, the officer, if someone does an MPAA request for their records, the officer has to be notified. And then we're going back and looking at some of those records, and we're finding that some of these records are for an officer using profanity, and the entire issue was captured on body-worn camera, and the officer never used profanity. But now that is being held against him in public opinion that he's a bad police officer because he must be bad because he has all these complaints.
Are you aware anywhere else in Maryland with any other type of employee that unfounded complaints or exonerations and the complaint itself, and I guess the disposition, I guess if someone checks this record, they will see that it was determined to be unfounded or exonerated, but you can also see the full extent of the complaint.
Yes, ma'am.
Are you aware of this happening in any other employment situation in the state of Maryland, public or private?
I am not, only because I don't know of any definitely public employee
All right.
that's records are open to the public.
Well, that's true too. And then the public defenders, I haven't been able to read everything, and I think some of their issues really cannot be placed on the officers about whether these committees are backlogged, whether these committees are staffed or not. That has really, to me, no relevancy to cases that have been concluded. But they do make one claim, and I don't even know the import of it. So, their third issue is amending the law to allow for expungement would authorize the destruction of potential impeachment material, which is required by law to be preserved and disclosed in criminal cases.
I think it would be very difficult for an officer to be impeached on an unfounded case.
Well, do you even understand what they're envisioning?
Yeah, I do, because I've seen it happen in court,
Okay, what is
where
it?
judges should be excluding unfounded and exonerated complaints from being used to the credibility of the officer. However, unfortunately, even if it's unfounded or exonerated, some judges do allow it in to affect or negatively affect the credibility of an officer's testimony.
I feel like saying, are you kidding me?
No, I'm not.
I mean, it's appeal. I mean, it's an error so large it deserves a mistrial, but this is happening. And of course, the officers, the case can, whatever can happen, you can appeal this and take it up, which is expensive and laborious. So I don't know of any evidentiary rule that would let this in. All right, thank you very much.
All right, so further questions from the committee? All right, with that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. We have Ms. Levy joining us virtually. Welcome.
Thank you. This is Debbie Levy from the Office of the Public Defender. So I think I'll start with the senator's last question on the point that we raised about information being discoverable that goes to impeachment material. So let me start with a couple things. First of all, the ACC units, there's a backlog, particularly in Baltimore, of 700 cases. Just last year, this legislature passed a bill to give the administrative charging committees a little bit more time, because as by their own admissions, the 30-day turnaround that they had, if a law enforcement agency investigates misconduct and then sends it to the ACC, they did not have enough time to thoroughly investigate and would make decisions that were not based on a thorough investigation. So for that reason, there should be some pause. Hold on a second, the legislature just decided to give the ACC more time to do meaningful investigations. Now let's get back and look at the propriety of destroying evidence. So a couple things to think about is that a law enforcement complaint can have multiple allegations. And this legislation is not clear enough to say if the false statement was sustained and then the failure to supervise was not, are you wiping out the entire complaint, the entire file versus the single allegation? We have an officer who was just fact sustained for false statement and false report. While he was awaiting final disposition, he made a settlement and his false statement went away. It didn't get to the ACC. It didn't get to the trial board. They just decided in agreement to banish it. That's like an illegal expungement from our perspective. And he just testified that he didn't have a false statement, even though he was considered to have had one. As to Senator Folden's comment that these are all public and open to inspection, I myself have filed PIA requests with every administrative charging committee in the state for their conclusions. Only 4 jurisdictions provided results to our PIA request. Every other ACC in the state told us that the records are not considered public because they don't know what the chief of police did after they gave their discipline recommendation back to the police commissioner. And so his fear that these are out in the public is not true. And I can give the senators all of the letters that we got in response saying this information isn't even public. So I think the parade of horribles doesn't exist. It's too soon. I urge an unfavorable report.
All right, thank you very much, Ms. Levy. We have a question from Senator Folden.
Thank you.
Thanks for your testimony. Did you just testify that you thought that it was reasonable to expunge criminal complaints for purposes of education?
Oh, thank you, sir.
previous bill?
I didn't testify in the last bill. No, that was some other person, but no, I was not. The last bill that I testified on was Senator Sidnor's, Senate 321.
Okay, and that bill was the body cameras. Okay, thank you.
Yes, sir. But
And so when you
congratulations,
said-
Hartford County did give us some of the records.
When you said you petitioned, who did you write your PIA request to?
To the administrative charge, every administrative charging
Yeah,
committee
you
in
did it to
Maryland.
the ACC, but that's not what I spoke of. I spoke of if you do, isn't it true that if you write to a law enforcement agency where the HR files are kept, that's what this is about. This isn't about the ACC's responsibility and turning over information. This is about an HR file where their complaints are founded, that they are open for public inspection at any time.
They're not kept in the HR file. They're kept in the ACC and the Internal Affairs Division. They're
No, ma'am.
specifically
No,
not.
they're kept in multiple places.
All right, just hold on, let's just make sure, let's not cut each other off. So, Ms. Levy, go ahead, you were speaking, and let's just take it.
Well,
you can
it's a
correct-
matter of fact.
I know,
She's
can
speaking
correct- you can
inaccurately.
Let her finish,
Okay.
and then you can correct her afterwards, or you can continue the colloquy, but go ahead, Ms. Levy.
From my experience, 20 years as a criminal defense attorney and litigating these pretty aggressively since 2013. My experience is that they are housed inside of the Internal Affairs Division. A personnel record in the HR file is significantly different, and we don't access that information. That the HR file continues to be a confidential personnel record. Passage of tests, qualifications to serve as an officer, those are not part of the Internal Affairs records. Internal Affairs records are housed in the Internal Affairs Division and also in the Administrative Charging Committee Division.
So is the officer's internal affairs file open for public inspection?
Well, I think that's the idea of the Police Accountability Act of 2021. In actuality, is that happening? In most jurisdictions, they're charging, as I've testified previously, for example, if I give a PIA request to Hartford County Police, I may get something called a very brief summary of the records. The State's Attorney's Office of Baltimore City insists regularly on redacting everything. The Baltimore Police Department will give us a very brief, truncated summary that somebody else wrote. We are not regularly yet getting the complete files that you would think that we should get based on the passage of the act. The law enforcement agencies across the state have aggressively pushed back against complying with that aspect of the law.
But the answer is yes.
No, the answer is we get summaries. So for example, Montgomery County gave us $1 million request, $1 million fee to get the full files. And it's as if they've all sort of gotten together and said, hey, let's tell them we'll give them summaries, and then they don't get the full files. I just was in court this afternoon for 2 hours litigating even in a criminal case, whether or not we get the full falsity, with the full file. I have an officer who failed an integrity test. They don't want to give us the full file. We still have to pull like tooth and nail and litigate for the full files. We have not yet realized the transparency and accountability that was the intention of the law.
Senator and Ms. Levy, I think, and if you can both agree on this or not, but I think you're both right. So the statutes make
the statute's clear.
Statute says that, but in functionality and on the ground, that's not playing out. But the statute says that.
But if the statute says that,
that's right,
and it's a matter of law,
that's correct.
Then whether that would be a compliance measure to address.
100%.
That
and also,
so they are open for public purview.
That's right.
And inspection, and there are also no restrictions on how those that ask for those files are able to, what they're able to do with them, is there?
No, that's true, and so too is the unavailability of the records because of those administrative hurdles and the excessive fees that are charged. I think those are
Isn't there something that says about the excessive fees? So $1 million is reasonable by Montgomery County?
We went to the ombudsman. That's the process where you can go to challenge the fee, and the ombudsman asked Montgomery County to adjust their fee, and they increased it. And we get these kinds of fees everywhere. And we are one of the largest law firm in the state, but also limited, just like police officers are limited. We're all limited in resource. And so do we want to file a lawsuit every time? We don't have the capacity.
Did you say that you asked Montgomery County for the full, like just everybody's file? Is that why it was $1 million?
No, sir. we targeted individuals who our clients had generated specific instances with. So I think there was, if my memory is correct, and I've provided this previously, and I'm happy to provide it again, but maybe there was like 14 officers, one officer's files alone, they were charging a redaction fee of almost $100,000. So we regularly only get summaries. I mean, which if you're worried about, so much being disclosed in the universe, I can tell you that's not happening. It's just
Well,
not.
I can tell you that it is happening because it happened to me.
All right,
So we can agree to disagree, but I will let you know directly that it is
You got to
happening.
let her finish her thought, and then
She was done.
I don't think she was, but let's let her finish. And then we'll go back and forth.
Just because another senator gets up because she's upset doesn't mean that I get interrupted. She was finished.
She was
and
actually,
she's over there
not.
tantruming.
I'm not even looking over at anyone else. I'm looking at you two. So
thank you for your testimony. I appreciate your time, ma'am.
Senator Folden?
Yes, ma'am. I would love to get with you on those 14 people.
Senator, let's let her finish her statement, please.
I was just going to say that we are not, in theory, opposed to this idea of, at some point in time in the future, getting rid of things that have been fully investigated and that have been fully found to have not happened. That's not an unreasonable thought on your part. But I don't believe, based on our boots on the ground experience with the law, that we have arrived at that place yet. And I would suggest that we partner with you on transparency around why officers get on these Brady lists. And how is that managed to be kept secret? And even officers should know how they get on a Brady list. And we can talk about ways for them to petition to get off of their Brady or do not call list. So we are not opposed to every idea of even protecting the entire process. But we are not ready for that yet here. That is my perspective.
And I appreciate you sharing that. What I will say is that in this piece of legislation, I'm pretty sure it said specifically that it was 3 years after the conclusion and determination of it being not sustained or exonerated. So I believe that this bill actually accomplishes what you just spoke about, which is that this bill would still allow for public inspection 3 years beyond the end of the investigation. So the investigation could take, as you said, over a year now. So it's 3 years beyond the conclusion and being adjudicated by the ACC, that this bill would then put in a 3-year window that it still is available for public inspection, but then at the end of that 3 years window that the officer would be available to have them removed. That's all the bill does.
May I ask you a question, Senator?
Sure.
If the complaint, for example, the one that we litigated today, an officer may have a false statement, a failure to write a report, an improper use of force, and a failure to supervise. And and only the failures to supervise is exonerated. Would this bill anticipate that everything else would remain? Because it says complaint. And so if something's housed by a complaint number, would everything else in that complaint remain and you just redact out? Because I have never seen or rarely seen a complaint with one single allegation. So how do you handle that situation in this bill using the word complaint?
So the bill works with when it involves a member of the public and that the complaints are unfounded, exonerated, whatever it is. So if there is a sustained element of it, that sustained element would still be open for public inspection, obviously, and would stay on the file. But the elements that are a part of it, like you said, I would imagine it would be redacted because it was not sustained.
Okay, so that's the last word on that. We'll take this colloquy offline.
Thank you.
If there's any more on that. Are there any other questions from any other senator? All right, thank you all very much. With that, that'll be the end of the testimony for Senate Bill 330. We'll now move on to Senate Bill 331.
Mr. Chair, Mr. Vice Chair, esteemed colleagues of Judicial Proceedings, for you today, Senate Bill 331. For the record, William Folden, State Senator representing Legislative District 4. Senate Bill 331 is just a simple, really an extension, if you will, that would permit an issued retired law enforcement officer who retired in good standing from service with a law enforcement agency within the state or county or municipal corporation of the state to basically maintain their certification through LEOSA for a matter of 5 years instead of the current term, which I believe is 3, if I'm not mistaken. And this, after the Bruin decision, we saw a significant influx of applications through the Maryland State Police that they had to do background checks on for permit holders. And again, this is a very reasonable request to ask that those who have carried a weapon legally and in the defense of our state for a term of time that gets them to a retirement, that they would be able to maintain that permit in a term of 5 years instead of 3. And with that, I would ask for your favorable report of SB 331, and I'll turn it over to my panel. Thank you.
Good afternoon, Chair. Well, good evening, Chair Smith, members of the committee. Manny Giraldo, Cornerstone Government Affairs, here representing the Maryland Troopers Association. I'm joined by Mike Alt, who will testify next, an Air Force veteran and a retired trooper, state of Maryland. Kind of what Senator Folden said, and I appreciate him to reintroduce the bill. This bill passed last year. It's a straightforward approach. We want to go from 3 years to 5 years. These are troopers who have served in the state, and this is really just kind of a technical kind of bill. So for these reasons, we urge a favorable report, and I'll let Mike Alt speak to it as well. Thank you.
Honorable members of the committee, good evening, afternoon. My name is Michael Alt. I'm a retired first sergeant with the state police, and I'm here to speak on behalf of the roughly 1,200 members of the Maryland State Police Alumni Association who this bill would impact. I guess to begin with, I don't want to reiterate what the senator said, but I don't see a negative impact to this bill. The individuals that it impacts have all served the citizens of the state of Maryland honorably and have retired in good standing within the state. And it's a small thing for them not to have to renew as frequently, but it's still something that I think the rank and file is deserving of it. I personally don't feel there's any negative impact to the bill. I think if you look at it in terms over a 10-year period, taking that the one renewal of the concealed carry permit saves the state roughly a third in man hours. I don't know what that equates to financially, but I mean that's advantageous to the state. And additionally, there is no fiscal impact. In that all the law enforcement officers that have obtained their permit through this mechanism, there's no fee involved. So those things to consider, I don't see anything negative to go with it. In addition, I'll point out that many of the officers that carry a Maryland concealed carry permit also carry a LEOSA permit, a federal permit that allows them to carry in all 50 states. And that has a requirement that has them qualify and seek training every year that keeps them more in touch with what their responsibilities are for the concealed carry. So that's it. I just ask that the court find favorably in favor of this bill. Thank you.
All right, thanks. Questions from the committee for the proponents of the bill? All right, seeing none, we'll switch over to favorable with amendments. Mr. Penick, you're up.
Thank you, Mr. Chairman. Mark Penick, President of Maryland Show Issue. We are in favor of the bill with an amendment, which is to extend the 5-year period for initial expiration and for renewals to all carry permit holders. All carry permit holders. That is the norm nationwide. Right now, the Maryland State Police has almost 200,000 permits that are subject to frequent renewals. I talked to Captain Rosenthal yesterday when he was over in the House. He said right now it's 197,500 and change. So that varies a little bit over time, but this is a waste of money. So the norm not only is 5 years nationwide, but it's 5 years in anti-gun states. New York is 5 years. Massachusetts is 6 years. Our neighboring states are all 5 years for concealed carry, including Delaware and West Virginia, and Pennsylvania. So across the nation, 5 years has been adopted. 2 years are only applicable in 2 other states. This legislation of 2-year expiration dates back to 1972, when Chapter 13 was enacted by the General Assembly. There has been a lot of changes since then, including computerized research. The FBI's wrap-back system is now in place. The Maryland State Police can revoke a Maryland carry permit at any time for any reason that is sufficient to otherwise disqualify the applicant. There is no reason other than a waste of money to continue to insist on 5 years. It's good government, if nothing else. So for that reason, we urge the committee to favorably report this bill with amendments. Thank you.
Thank you very much, Mr. Pennick. Thanks for hanging in there with us tonight. Questions from the committee? Seeing none, that will conclude the hearing for Senate Bill 331 and our hearings for the evening. See you all on Monday evening on the floor.
Sarah,